if there can be any possibility, let it be
What
on
is the urgency?
Tuesday.
So what is the urgency?
Regarding the appointment to arbitrator, my lord, for last 6 months the matter is pending.
It may be pending, but that can't be attributed to the court alone.
But it was directed to be listed today, my lord.
Maybe it may not have been listed for some reason. But next week is motion day. It is not for motion.
Let it be so, my lord. If possible, my lord, let it be taken up.
Let it come after vacation immediately, 14, 15, 16, whatever date
My
you want.
lord, during that period, I may be out of station, my
Right
lord.
after you come back, we'll have it. Let it be immediately after you come back, whenever it is convenient for you.
My lord, let it be in the last week of July.
All right.
29th, let it be.
29th?
Yes.
29th of July. You have to correct the date.
Yeah.
29th of July.
May please, Your Lordship, I have to mention listing for Urdul Mal. Listing for Urdul Mal.
Withdrawal tomorrow.
Yes.
Tomorrow. Where is the petition?
One thing I'd like to clarify, sir. The de novo inquiry was not based on new charges. Sir, I have already submitted. No new search as such, my lord. The Stokoe's notice was same, my lord. Only he was given the opportunity. Because in the first occasion, my lord, he was not given the list of documents and list of people. Because of that, authority, my lord, duly considered that aspect on his demand also, my lord. He is also all along demanding.
We will pass orders next week.
Yes. That part I
Tuesday, Wednesday. Okay. This is for admission, right?
today it has come for.
No, but otherwise it was for admission.
Yes. No, my lord, it was hearing.
Hearing.
Hearing. In fact, your lordship has concluded.
Is there anything further you want to supply?
No, further only that part, man. The last occasion, because my learned head submission, that effect, that is an clarity. And demand was also there all along.
Lordship, any date?
Only to give the ample opportunity to the petitioner. My lord.
We did not want to reserve it.
Right.
So otherwise we can reserve it and deliver it.
Right.
But let us make an attempt to deliver in court.
Yes.
On Tuesday.
Tuesday.
Next Tuesday, madam.
Wednesday.
All right.
Yes. They
25th.
Can it be on Thursday, Lord?
Thursday, all right. 26th. 26th.
Much obliged.
26th. Yes.
So these matters relate to appointment of disabled person. Initially, one SLPRB, the State Level Police Recruitment Board, was entrusted to hold the whole recruitment process, and subsequently, it was handed over to the Guwahati University. And initially, the SLPRB adopted a process of digital viva. In the digital viva, what happened? The one computer screen, they have to choose the option, and they click in one option, the correct option, and the result is instant result came out. So it was more transparent, more and after about 7-8 districts, digital viva has been completed, and subsequently, the Guwahati University, they hold a written statement, written interview, while the annexer Lordship has taken up the review petition, my lord, 57.
57, yes.
Yes. My lordship, if your lordship find that page 110,
What is
And-
that review? Which order you want to review?
my lordship will find,
321.
yes, my lordship, a relevant portion, my lord. The writ petition was dismissed, my lord. At that time, my lord, some vital fact could not be brought into record, my lord. This, particularly these two notification, Annexer 16 and 17 at page 110 and 111. And one more thing, my lord, there was the cabinet decision to hold a digital Viva. Earlier, my lord, it was hold, the white order that the lordship will find at page 108, my lord, of the judgment from paragraph 9. May I read, my lord? It
Yes.
appears 108, my lord, page, paragraph 9. May I read, my lord?
100 and
108, my lord,
Ah.
page,
para 9.
para 9.
Yes.
It appears from the report that digital Viva so far conducted for recruitment to the post of grade 4 has been cancelled. But before doing that, so the association representing different categories of physically challenged people in Assam were taken into confidence in the meeting held in the chamber of Honorable Minister Social Welfare Department. Besides, the cancellation was necessitated due to the hue and cry raised by the people against the manner in which the examination was conducted. As such, this court is of the view that examination process which has been already cancelled under such circumstances cannot be carried over. That too, when the recruitment process has been taken over by a different body other than the one which conducted earlier. Thus, I find no merit in the first prayer of the petitioner. Accordingly, it is rejected and dismissed. On the second prayer, to hold the recruitment process through digital Viva interview after careful perusal of the interview, I find no mention having been made about it or even indicating that recruitment process to the post of grade 4 post should be through that method. Therefore, there has not been any change in the rule of the game. It was adopted
So,
by the.
why the review?
So, my lord,
Where is the error apparent?
earlier, my lord, earlier there was a cabinet decision. That facts could not be bring into the record, my lord, at that time. Because there was a cabinet decision dated, my lord, 9/10/2018 to hold, my lord, digital Viva because it was much more transparent. And my lord, Annexer 100 and
No. Review, is only to
my lord,
find out the error. Where
Yes,
is the error apparent?
because my lord, had this, my lord, Annexer 16 and 17 brought to the notice of this court, my lord, then my lord, result would have been different. Because, my lord, for the, my lord, grade 3 and grade 4, written test, my lord, interviews in the junior level post in the government was, my lord, stalled. My lord. Now, my lord, it was adopted by the consortium outsourced by the state level police recruitment board for their own convenience and not as chosen or prescribed by the respondent. Therefore,
No, you are seeking a review in terms of section 9. Paragraph 9 of the judgment.
basically
It is an error
dismissal of the dismissal of the repetition on these two grounds, my lord. Well, when the, my lord, state government and central government, my lord, they, my lord, held that the, my lord, interview for junior levels not to be conducted. And lordship earlier order directed the respondent to obtain instruction whether these two notifications are still holding the field.
You are addressing a review matter. So
Well-
tell us where is the error apparent. Your arguments not being considered, etc. Get heard before the appellate court.
Because,
You
my
have
lord,
to be an error apparent.
yes, I have stated, my lord, that these two notifications and that the facts that there was a because
that is not even the grounds on which your first contention has been rejected.
yes, earlier, Honorable Single Judge has held that it was the decision to hold the digital viva by the consortium, outsourced SLPRB. But in fact, it was the decision of the government. Lordship, Lordship,
Then it becomes the ground for it.
if I
Then it-
pray, my lord,
Then it
Otherwise,
is not an error apparent.
Yes. Otherwise, my lord,
If it is a case that the finding in para 9
my lord,
is contrary to materials which are available before the court, supposing those two notifications were there, or it is, or some other averment is there, it has wrongly been appreciated in para 9, then it's a different issue.
Lordship, may I pray, my lord, in this case, I have been led by Mr. K.N. Chaudhary, my senior advocate. He is out of station, my lord, as I have told. My lord, may I pray for any other convenient date, my lord?
Convenient, every day is convenient for us. You tell us when it is convenient for you,
Before vacation, my lord.
not before, after.
Seventeen, my lord.
Indeed,
July.
20 July, as requested for by the council. For the,
My lord, Lanesh senior friend is engaged in another court.
whatever, 17 July, has been prayed for by the council. For yes.
Shubin, item number 6, Lordship, the ceiling proposal has been approved and the budget has been released to the Soil Conservation Department now, Lordship. They can make the payment once the bills are prepared and sent to the Treasury Officer.
7 days time may be allowed.
In deference to the earlier order, dated 13/6, the finance department has placed before the court the instruction received. The perusal of the instruction revealed that fixation of ceiling FOC proposal for an amount of rupees 1.76 lakhs in connection with the contempt case has already been issued by the finance department. Stop. Learned Standing Council Finance submits that since the ceiling has been ceiling proposal has been issued, the funds have already been sanctioned to the Soil Conservation Department. So, Mr.
Yes,
P. Hazarika,
number 1 here.
on behalf of respondent number 1, 3 and 4, submits that he would like to obtain instruction with regard to the release of the amount stated to have been release of the amount to the petitioner stated to have been released by the finance department, sanctioned by the finance department. He prays for a week's time. He prays for we can't give you a week. He prays for time, considering that the fact that the amount now is required to be paid. Bills are already prepared or not?
Lordship, usually it takes 1 week's time, Lordship, from what my
Yes,
Next week, Lordship, 25th.
1 week time will not be 25th.
we may fix it immediately after vacation. In the meantime, the payment might, Lordship, will most
It is
probably
after
be
reopening.
immediately.
that view of the matter, let the matter be considered. 16th of July. By which time it is expected that the respondents will comply with the directions contained in the order dated so and so, passed in the
Massive.
Title 19. Here the matter was heard length
Yes.
and Manoj,
Mr. Chaudhary.
Yes, my
The basic ground, there are essentially two grounds. One is that the question of maintainability of the rate. Are there any specific judgments that you are referring to
Yes, my lord.
in support of your contention?
earlier that on the day of the argument, he had placed two and three judgments, my lord. One is the NCRT, Chandramohan NCRT. Then the other one is the rate appeal 5 of the 22.
NCRT.
Chandramohan versus NC 1991 for SSC.
We don't have that.
Right,
We don't know it.
And detail number 5 of 2022. Then, my lord, another judgment is there, my lord, on 1989 to SCC. Page 6.
Give us a list.
Yes, I will give.
You give us a list.
List is there, and I got the citations also, and I have highlighted the.
Hmm?
I have got the citations also, and I have highlighted the relevant.
All right. No, you give us a list and the paragraphs number. Give us a list.
Of the 8 SCC 92.
Have you shared the judgments with him?
No, my. They also not have it.
Look, my lord,
It's okay, I will share.
Which judgment you are 2008?
Of the 8,
2008, 8 FC.
90. 19. Regard the contractual service. Contractual.
You did you play? You did not place the judgments on the last appeal.
I played one detail number 5 of 2010. Then for 1991 for SCC 578.
1991.
For SCC 578. Another.
This is for the proposition that what is the state? What is the issue in the matter?
Here, my lord, the thing is that with memorandum of association, there are a number of objectives are there. So all the objectives are not for the government. Similarly, in this case also, the memorandum of association has got several other objectives. So those objectives are not for the government.
the affidavit in opposition, page number 82, annex 30, memorandum.
No, but how do you respond to the judgments referred to by the petitioner on this aspect?
There basically their points are there is violation of nature and justice for one, and number two, there is deep and pervasive control of the government.
No. The first question is that it is maintainable because it is an extension of a state or it is an instrumentality of the state. And they have relied on some judgment. I think Gritco is one of them.
It was related to termination. Pradeep Biswas is related to state.
Pradeep Biswas. So vis-a-vis that judgment, how do you respond?
My lord, with regard to writ appeal number 5 of 2022.
5 of 25 is on a different aspect.
5 of 2022.
That is on the aspect that the employees had asked for similar pay benefit.
Yes, my
So
lord.
it was in that context. The court held that they are not a state.
No, even if it is a state, in that case also, they don't have any rights against the government. The government doesn't have
So
any.
let us not digress. First thing, you are questioning the maintainability of the writ petition, that it is not a state. If it is not a state, then the writ petition must be dismissed. So they have relied on certain judgments to support the case that it is not just financial benefits or anything. If it is rendering welfare services, if its services are to the extent of in the nature can be identified to be public functions, then the rate is maintainable.
In my case, only NCR says that NCR 1991 for it. With regard to other objectives, it is not considered as a state. In the memorandum.
Are you trying to distinguish the judgment or you leave that to the court?
I leave that to the court.
Okay.
It's up to the court because
Malad, I'll just indicate one thing, Malad. My learned friend is referring upon Chandra Mohan Khanna. Malad, that was the time when the law was evolving. Now, if your lordship just have that one paragraph 87.
We had heard you.
Yes.
Only question is when we were going through the records, we found that the judgments of the respondents were not available in this record. We thought let us.
Lord, my only submission is that juristic person, how it is constituted, whether it is a company, whether it is a corporation, in other has said it was a society. Under the society is registered. It is immaterial. What is material is what is the extent of control of the government, what is the extent of finance involved in the case, what is the extent of, my lord, statutory compliance is required by the authority to be done. For example, in that 89 case, my lord, Honorable Supreme Court says even a writ would lie against a private body also when it comes to enforcing a statutory obligation. Supposing in this case also, my lord, under that statute, that
Which judgment?
No, I'm relying not on judgment, my lord. This Maternity Benefits Act of 1961, which is involved in this case, because I'm undergoing pregnancy, I'm entitled to those benefits also. So that part is also involved. Honorable Supreme Court in an 89-2, that, my lord, 89 case, where it said, when it comes to enforcing statutory obligation, a writ would lie even against a private party also. May not be for any other thing. Supposing, my lord, they are not deducting my provident fund, then I can always maintain a writ petition saying, how come you are not deducting provident or not giving me benefit? So, my lord, over a period of time, things have changed. End of the day, no, my lord, these are the functions which government is otherwise supposed to render. But because of the, my lord, limitation of the bureaucracy, now this extended arm of the state has emerged. And they're doing what? They're discharging governmental function only.
Yes.
My lord, cancer hospital is what? Yes, another public-private body has joined hand with the state in discharging that sort of function. Therefore, to say that we are not state, we are defeating the very purpose and objective of the whole scheme of things. Therefore, my humble submission is, my lord, there can be no manner of doubt that REIT would be maintainable, my lord. And on the merits, I have already made my submission.
And one small submission regarding the maternity benefit. We are not denying the maternity benefit anywhere. The only thing is that she will have to apply in the proper format of the. We are not denying that.
All right.
Deep,
We'll keep it for Monday for orders.
deep.
You mentioned that there's some extension granted.
Extension granted up to 30th September.
Mr. Saikia, why do we take up the matter today? We'll go for a detailed hearing after the vacation.
I have no objection.
They're already protected.
Only up to 30th.
September. We'll list it immediately in July.
Immediately,
No,
On a-
23rd,
on a-
24th of July.
only on a Saturday,
Hearing-
Tuesday or Thursday,
Hearing day.
hearing day.
All right. List it on July
24th, if it is not inconvenient.
24th.
Lordship will just bear it.
24th.
My lord.
Submitted. The applications are protected by extension by the state. 30th of September. Let these matters be listed for hearing.
My lord, it will come up for admission hearing.
Admission. Why? Pleadings are complete.
Hearings are come.
This admission hearing creates a problem because
Because I was not.
because if we have to go for a complete hearing, full hearing, then it should come up for hearing.
My lord,
No,
Otherwise,
let it be on, as a hearing, in the hearing column on 20.
On
Because
24th.
I was missing a number of years. The practice that time was admission hearing, then orders like this.
No, admission hearing is to decide whether it is to be admitted or
Admit or
dismissed.
not. My lord, I understand. Let it be for hearing.
Here is a case where it appears that you are ready for a full argument, both of you. So therefore, we'll assume that it is to be admitted.
Sometimes
hearing.
we have also motion hearing.
Motion hearing.
Motion hearing will be-
Motion hearing.
List
Yeah,
on
we don't say order hearing, but in court number 1 till few days ago, all orders matters were heard.
Even in orders also.
finally.
And then this,
All right, we'll say this is for admission. We'll let it be for admission. We'll take it up for hearing.
Right.
July 24th, be listed for admission hearing.
How was that?
highly ordered.
As the
Mun not mun not was. Pues to pistache probada. To pi. To aton na. Está con problema na.
This is a part third matter, if I'm not wrong, Doctor. I have completed my
factual arguments and submissions also, I have to place few judgments, the authorities. That was the only left out part on my part. Just to recapitulate the basic facts or the facts in a nutshell, Lordship. In 2019, the writ petitioner was appointed after she was selected by APSC for the post of ALR, and she was posted as circle officer in Margarita, and she joined and she was doing duty. One complaint came that her caste certificate was not proper, was not properly issued. The inquiry was done, she was given opportunity, and thereafter, the state level scrutiny committee found that her certificate was not properly issued and it was cancelled subsequently. They came before the Honorable High Court. The court at the first instance, Lordship, on 24th of November 2022, set aside the cancellation order as well as the scrutiny committee's finding on the basis of the report given by the vigilance officer. There was a parallel inquiry of the deputy commissioner's side. That inquiry said that her certificate was wrongly issued, but the contra view was of the police officer or the vigilance officer. Against that, while the government was preparing the file for filing the appeal, the third party who was actually lost the complaint, that anti-corruption body of the So that appeal was dismissed on 1st of June 2024. 2023. So government could not file the appeal and government went for the review, and in the review, we took a lot of grounds, including some subsequent developments. The government, while implementing, at the course of implementing the order, found that two opinions are given by two different authorities. One by the vigilance officer, the other was by the circle officer. The government wanted to know what is the reason behind of having two opinions on the same factual matrix. It was found that the first officer, the vigilance officer under the CID SP, did a very improper inquiry, not finding out the actual facts. He was giving his opinion basically on the legal points. And government also decided that who was at fault, and it was found that he was at fault. Then government directed the authorities to conduct a fresh inquiry.
Just 1 minute. Just 1 minute. Sorry, yeah.
Yes. So government went ahead with a fresh inquiry on 26th of December 2024. It was found that the inquiry, subsequent inquiry disclosed a lot of other factual aspects on the basis of which the writ petitioner is found to be not eligible for getting the OBC certificate. Government issued a notice on 27th of December last year. That notice is put to challenge here instead of going. And in the meantime, the review also, we have put all the things before the Honorable Court. And a stage has come to the Honorable Court that even if the inquiry findings of the subsequent inquiry are found to be correct also, then also the main course of action will have to be done as per the guidelines issued under the Madhuri Patil's case of 1994, on the basis of which one OM was also issued by the government of Assam on 11th of May 2018. So the court gave us an option that whether you want to pursue the review or you want to conduct an inquiry as per the guidelines of Madhuri Patil and the OM of 2018 of the state government. In response of that, already we have issued the notice and they have decided not to pursue, decided not to give the response. So the Honorable Division Bench in the review application gave us the option, what option we are going to adopt, either of the one. Then we decided not to proceed with the review application. Instead, we decided to proceed with the inquiry by the state level inquiry committee as per the guidelines of Madhuri Patil as well as the OM of 2018. In this case, that subsequent inquiry by the state level, that is put to challenge. That is under challenge in this case. So whether we can do it or not. I have placed all the material facts and also distinguished the basic differences between the inquiry report of 3rd October 2019 and the inquiry report of 26th December 2023. I have given a chart to this honorable court, and in the first part, if we look at the inquiry report of 3rd October 2019, what are the salient features of that inquiry report? If Lordship is, or if Lordship on the second copy also, Lordship is having it.
We have
So, in the first inquiry report of 2019, the vigilance officer visited her paternal address and present address at Golaghat and Jorhat. So Guwahati did not claim. Father Santanu Borkakoti, born and brought up at Kilpukuri, Guwahati, and followed the original rights of Polita community and got appointment as medical officer, who was posted at Jorhat. He got married to a lady at Jorhat, hailing from Koch OBC community and resided at matrimonial home, wherein the Monsoon Borkakoti was born on 12/4/2019. This finding as matrimonial home, this is one of the areas where we are going to give a contra view, the subsequent. It is a parental home, not maternal home. Then Monsoon Borkakoti stated education at Jorhat and accepted customs of Koch community. She also studied in Guwahati. That part is not discovered by the officer who was responsible for conducting the inquiry. Then in 2006, as class 10 student, she applied for the OPC on merit of her mother's custom, and father did not belong to Koch community. So these are the basic 6 factual aspects which was discovered in the first inquiry. And he gives a lot of Supreme Court judgments and other ratios to give his finding that the certificate was genuine and there is no reason to disbelieve. In the subsequent inquiry of 26, what we have found, Monsoon Borkakoti is presently residing at Sekoni Dhora, Jorhat with her parents and younger brother. So it is not a maternal house of her. It is a paternal house, it is a parent's house, the parental house. Her father is residing together with his wife and children. Her mother is working in irrigation department, Government of Assam. Dr. Santanu Borkakoti was born and brought up at Silpukuri, Guwahati. His ancestral roots belong to P. Takoti Gaon. Golaghat village headman confirmed that the great-grandfather S. Borkakoti shifted his residence to Guwahati. Monsoon Borkakoti is the daughter of S. Borkakoti and they belong to Polita community, which is a general category. Village headman of Chekoni Dhora Gaon confirmed that Purnima Datta, mother of Monsoon Borkakoti, belonged to Koch community. Monsoon Borkakoti, during her higher studies, she was residing at her father's ancestral home at Silpukuri from 2009 to 2015. OBC certificate was obtained by Monsoon Borkakoti on 13/12/11/2006, countersigned by ESC Jorhat, showing that she belonged to Koch community. Name of the petitioner differently spelled in OBC certificate, which she used for APSC examination. Monsoon Borkakoti admits that her mother belongs to Koch community and father belongs to general community, general category. This is also very important, that according to her also, the father is general category. But what is the subsequent findings? The inquiry officer visited the office of All Assam OBC Association Jorhat, Congress Bhavan, to verify the documents submitted by Monsoon Borkakoti at the time of applying OBC certificate. Office records available on 2007 and OBC certificate was issued on 13/12/2000. So they do not have any records of 2006. From 2007, they have the records. Visited DC office Jorhat to verify the documents submitted by Monsoon Borkakoti for obtaining OBC. So no records found. DC office did not have any record at all. The OBC office also did not have any record at all. Dr. S. Borkakoti applied for OBC certificate. According to the doctor, he is a general candidate, general post. So Dr. S. Borkakoti applied for OBC certificate in February 2019. Fake OBC certificate dated 19/3/2019 issued in the name of Dr. S. Borkakoti, Purnima, that his father got a OBC certificate in 2019. Purnima Dotto was issued OBC certificate on 6/11/2019. So in 2019, when the process of inquiry by the CID officer was going on, the report was submitted on 3rd November 2019. So when the process started, the father obtained one certificate of OBC and mother also obtained one certificate after the inquiry report was submitted. Father obtained it before the inquiry was completed. Official record of Monsoon Barkakoti's brother shows that he belongs to general category. So the brother also is a general candidate. Findings. Monsoon Borkakoti's parents were never separated nor divorced and were residing together. Monsoon Borkakoti did her schooling from Jorhat and resided in her father's ancestral house at Guwahati for her higher studies. She falls into the creamy layer. So these are the additional findings which have a major bearing in the outcome of the opinion given regarding the certificate. So when these additional facts were unearthed or these were came into light, then the normal duty of the government is to again fall back to the guidelines of Madhuri Patil and the OM of 2018. So that process was started. There is no bar in any manner that the government does not have the power to go for fresh inquiry. Now, their whole case is that as the division bench has given the opinion that the certificate of 2006 is valid, and also the learned single judge gave the same opinion, and in both the opinions, both the judgments of the Honorable High Court before the My Lord Justice Jamir as well as the division bench, the whole conclusion was based on the report of the inquiry officer of 3rd October 2019, 3rd November.
Single judge allowed the writ petition because the SLSC did not, for was of the view that the SLSC did not take into account the inquiry. That was the ground.
No, the ground is like this, Lordship. It is very clearly written.
SLSC directed the circle officer also to conduct some inquiry, which gave a contrary report.
The single judge, if we come at to page 240, let us find it, Lordship. Page 240, the order dated 24/11/2022. The quoting of the report is at page, the whole report is quoted here. Page 244. In respect of Monsoon Borkakoti, this is the report. And previous page, is 243, at this stage, D. Mojumdar, Learned Additional Advocate General, Assam, has produced the record before the court, which contains the inquiry report submitted by the Superintendent of Police CID Assam with regard to OBC certificate of the petitioner. The inquiry report is dated 3/10/2019, made by the Inspector of Police CID Assam. The inquiry report is also reproduced herein below. So on the basis of this, now Lordship will kindly come to page 247. A perusal of the inquiry report dated 3/10/2019 clearly indicates that the allegation brought against the petitioner is based on no truth, and accordingly closure of the inquiry was recommended. Perusal of the records produced by the Learned Additional Advocate General also indicates that the respondents has proceeded in terms of the procedure laid by the Honorable Supreme Court in the case of Madhuri Patil, and the final report submitted on 3/10/2019. Accordingly, considering the inquiry report dated 3/10/2019, the impugned speaking order dated 26/2/2021 issued by the state level scrutiny committee against the petitioner is set aside and quashed. So the learned single judge totally relied on the report. Now, by the division bench went one step further. That division bench judgment, Lordship will find from 249. Here at paragraph 4, the submission of the writ petitioner's side or the respondent in the appeal. Here also the reports, if Lordship is pleased to come to paragraph 4, the middle part. In Kumari Madhuri Patil Supra, the complainant with allegations of fraud in issuing the OBC certificate of the was inquired into by the vigilance officer under the Superintendent of Police CID. The Inspector of Police CID proceeded to conduct an inquiry, recorded evidence during the course thereof, and thereafter submitted a detailed reason inquiry report dated 3/10/2019, concluding that the caste certificate held by the respondent petitioner was genuine. He further submitted that the date of birth of the respondent was 12/4/1990. The mother of the respondent, Purnima Dr. belongs to Koch, which came to be recognized as OBC in the central list of OBC for the state of Assam in the year 1993. He submitted it as the respondent petitioner was born before Koch community was included in the central list of OBC. Manifestly, her birth certificate could not record that she belonged to OBC. However, based on the facts, the girl child was residing with her mother. So here also father is gone missing and was following the customs and rituals of Koch community. A certificate dated 3/11/2006 was issued. So here also their whole submission is on the report. Now, what the Honorable Division Bench said, paragraph 14, 259. In the wake of the discussion made herein above and keeping in view of the categorical affidavit filed by the state government authorities before the learned single judge on record that the report dated 3/10/2019, which was prepared after thorough inquiry conducted by the vigilance officer, the Inspector of Police CID Assam in the present case under the supervision of the SP CID conducting that the allegations regarding falsity of the social status certificate of Monsoon Borkakoti was based on no truth. The only course of action required to be taken as per the ratio of the judgment of Kumari Madhuri Patil was to accept that the said report of the vigilance officer of CID Inspector CID Assam. For the sake of repetition, it may be mentioned herein that the state level scrutiny committee, while passing the impugned speaking order dated 26/2/2021, did not objectively consider to the inquiry report of the vigilance officer, that is Inspector of Police CID, which was mandatory requirement as per the guidelines laid down by the Honorable Supreme Court in the case of Madhuri Patil. A perusal of the speaking order would reveal that the scrutiny committee, though referred to the report submitted by the Superintendent of Police CID Assam, but thereafter no discussion whatsoever was made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion that the respondent petitioner was not entitled to the benefit of OBC certificate, the scrutiny committee relied on a parallel report which was conducted through Circle Officer, Jorhat Revenue Circle. Apparently, in terms of the judgment of Kumari Madhuri Patil, the Circle Officer has no jurisdiction to carry out such inquiry. Furthermore, the findings recorded in the speaking order that the mother of Monsoon Borkakoti obtained caste certificate as belonging to Koch in the year 2019. It is also an extraneous and irrelevant observation because, as has been referred to supra, the service record of Srimati Purnima Dr. mother of respondent, her caste certificate mentioned is Koch OBC. Testing the report of the vigilance officer, the inspector of CID, on the touchstone of the principles laid down in Madhuri Patil, we find that the inquiry report submitted by the inspector does not indicate even in the slightest that the particulars given by the candidates were false or that the social status certificate had been fraudulently obtained. Thus, in terms of the first part of paragraph 13.7 of the guidelines formulated in Madhuri Patil, in which provides, in case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken. So the Honorable Court followed this principle. No further action was called for in the present case after the detailed and reasoned inquiry report has been submitted by the inquiry officer. However, SLEC got another parallel inquiry through circle officer who apparently has no jurisdiction to carry out the inquiry. Another significant fact which needs to be noticed is that the report of the inspector CID, which was submitted after conducting thorough inquiry in terms of Kumari Madhuri Patil, did not give any indication that the social status certificate was obtained by the respondent by providing any false or fraudulent information. Rather, concluded that the social status certificate was validly and lawfully obtained. The authorities has no option but to accept the report and affirm the social status certificate of the respondent petitioner as per the guidelines contained in paragraph 13.7 of the judgment of Kumari Madhuri Patil. Hence, contrary conclusion drawn by the state level scrutiny is absolutely illegal and unwarranted. So the division bench also basically relied upon the same report. Now that same report, upon subsequent inquiry by the government, was found that that report was not correct. Many major facts were not discussed or not unearthed. So in that situation, what is the option left to the government or to the honorable court also? So whether we can go for, because the report given by the inquiry officer on 3rd of October 2019, whether that is a report which cannot be touched in future. There is no such law. But the honorable court definitely at that point of time, while the learned single judge decided the matter or the division bench decided the matter, that was the only material available to the government as well as to the honorable court. So on the basis of the materials placed before the honorable court, that was the perfectly correct judgment. Now, government has found Madhuri Patil is one thing, the OM is another thing. Government wanted to find out whether the circle officer has committed a mistake or the CID office has committed a mistake. Because both are giving two different kinds of opinion regarding the same certificate and regarding the same facts. While doing that exercise government in its administrative capacity, lordship, is always permissible. But when very startling facts have come into light, in that situation, first we went to the division bench by filing a review application. During that course of time, the honorable court also found that there is substantial materials. But even if a review is allowed, we will have to fall back onto this process. And while on one hand, we are pursuing the review, and on the other hand, we are also pursuing the process as laid down under OM of 2018, as well as Madhuri Patil's case, paragraph 13. So two parallel proceedings was going on. Honorable court pointed that to us. And in that situation, we have decided that we'll pursue only one course of action. And that course of action is precisely which is put to challenge by the writ petitioner in the present proceeding. If lordship is pleased to look at the review withdrawal order. 300? Yes. 349.
Yeah.
Page number. On 28/5/2024, the learned AG Assam, on instruction, because the court has given us time to find out what course of action we are going to take. So we take a proper decision on the basis of instruction. The government AG so-and-so on instruction has submitted that the state does not want to place this petition since they are pursuing the inquiry initiated by them against the writ. So two proceedings are very, in this one sentence, everything is included. So we have decided not to go ahead. So review petition is closed as not pressed. So review petition was not dismissed also. So in that situation, whether a second inquiry is permissible or not. In that, to that point, lordship, I have a judgment. 2021 9 SCC page 811. J. Chitra versus District Collector and Chairman, State Level Vigilance Committee, Tamil Nadu. (2021) 9 SCC page 811, paragraph 7. Just referring to Madhuri Patil's case. Paragraph 7. Realizing the pernicious practice of false caste certificate being utilized for the purpose of securing admission to educational institutions and public employment, depriving genuine candidates for the benefit of reservation, this court in Madhuri Patil's issued the following guidelines. So it has been narrated. Now coming to paragraph 10.
Yes. Carry on.
Yes. In the instant case, an inquiry was conducted by the district level vigilance committee, which has upheld the community certificate in favor of appellant. The decision of the district level vigilance committee in the year 1999 has not been challenged in any forum. The recognition of the community certificate issued in favor of the appellant by the district level committee has become final. The state level scrutiny committee did not have the jurisdiction to reopen the matter and remand for fresh considerations by the district level vigilance committee. The guidelines issued by government GO number so and so do not permit the state level scrutiny committee to reopen the cases which have become final. The purpose of verification of caste certificate by scrutiny committee is to avoid false and bogus claims. Repeated enquiries for verification of caste certificate would be detrimental to the members of the scheduled caste and scheduled tribe. Up to here, it is fine. Now, next line. Reopening of enquiry into caste certificate can only in case they are vitiated by fraud or when they were issued without proper enquiry. So I am taking a cue from this observations of the Honorable Supreme Court that in appropriate cases, when there is an indication that fraud was adopted or when the enquiry was not properly conducted. In our case, it is abundantly clear from the chart that the findings in the first report and the findings in the second report, there is a multiple increase of the factual aspect, which are very crucial to determine the entitlement of a caste certificate. Here, not only the daughter has done all these wrongs, or the main regarding her education at Guwahati, all these were not even told before the first officer that she studied in Guwahati, stayed in her father's house, father's paternal house. And also, very clearly, it has been established now that she was not staying at her maternal home. She was staying with her parental home. Both father and mother and brother, along with her, were happily staying in Jorhat. And during the course of inquiry, it was also found, and the report clearly establishes the father has built that house. The mother has that landed property. She got it from her family line, legacy, by succession. And the father, who was a doctor, posted in Jorhat and Golaghat all along his career. He built that house in mother's property, and all are living happily there. It is not a case that father has deprived her daughter from all the advantages of a forward caste. She studied in the missionary schools there. She studied in the best college of the state. So she was in no manner deprived or any economic, socially, or educational deprivation. The law is very well settled that if a daughter or a son has to take the mother's caste, then she has to prove that she has deprived of all these facets, and also she was accepted by her own, the mother's community, as well as by her family also. All these findings, all these facets were not highlighted in the first report, while in the second report, the various areas were visited and all the opinions were taken, witnesses were called for, and a detailed inquiry was done. And in the inquiry, the most startling fact is that the parents of this daughter tried to mislead the inquiry officer in the first round. The father, while the inquiry was going on, the report was submitted on 3rd October 2019. He procured a OBC certificate in February 2019. So that shows what is the attitude and how they were conducting themselves in the area of obtaining caste certificate. Fraudulent activities of that family is well established. The brother, till now, he is a student of Bahana College. Till date, it was found out that he is a general category candidate. The mother also obtained a certificate in the month of November. Report was submitted in October, a OBC certificate. They have inserted OBC status in the service record of 2005. That can be done because if they can procure a certificate of the father without being a OBC, so and inserting or manipulation of service record is very much within their domain. They can do it. During that process, a force letter was also issued in the name of the deputy commissioner, that the deputy commissioner has verified all the records. That deputy commissioner herself, who is an IS officer, lost a complaint in Jorhat in 2019. Korati. Police found out that forgery and everything is correct, but who has done it? That could not be found out. Therefore, the case was closed. But that does not indicate that this exercise was not done. Somebody made an attempt, and who would have been the beneficiary? The beneficiary would have been the writ petitioner. All these were not found out in the first round of inquiry. So it was a perfunctory inquiry, it was an incomplete inquiry, it is a biased inquiry. And the inquiry officer relied upon more Supreme Court principles and judgments instead of the actual act he has to do to find out the factual aspects. He relied upon the opinion of the Supreme Court, who is eligible, who is not eligible. But to go to that stage also, he have to have the complete facts. The complete facts is that, and also their submission before the court, that the daughter stayed only with the mother, which was a blatantly incorrect finding. And when this second lady officer who was doing the inquiry in 2023, he wanted to go and meet the father. The daughter deprived her, saying that the father is unwell, so you cannot meet my father, to verify that certificate. So police has lodged a complaint. FIR was lodged against the father. Charge sheet has been filed, and the trial has started against the father. The police officer who committed this mistake in 2019, he was put to suspension. DP was drawn, and he is also facing the music now from the department. So now this first sketch I have just relied upon, that J. Sitra. So in our situation, it is a out and out a clear case that inquiry was not proper, and she obtained a certificate by fraudulent means. And when the records were tried to be found out, that office says we kept records up from 2007 onwards. Earlier records were all burned. The Deputy Commissioner's office, who has countersigned ESC of 2006, the Deputy Commissioner informed that there was no records available. So all this gives us a genuine reasons to believe that something fishy is going on. And therefore, it is not that we have come to the conclusion and we have believed 100% of the second inquiry report. Therefore, to rebut, we have to follow the principles of natural justice. So for rebuttal, that show cause notice was issued on 27th of December 2023. So that their side of the story we have to hear. This committee is not taking a decision beforehand. It is not a predetermined decision. They are giving that opportunity. You face the trial, face the inquiry, and if you can counter all these findings, the certificate will remain intact. Otherwise, it will be cancelled. And in the process, government is duty bound under the constitution that genuine candidates should get the benefit of this reservation, which the constitution provides. A undeserving candidate, a forward candidate, should not usurp a position reserved for a underprivileged or backward class candidate. So while she is doing a service to APSC and serving as a circle officer, she is now reinstated because of subsequent order that she has to be reinstated. So she is now depriving, if she actually had not procured the certificate genuinely, then she is now usurping the post which is entitled to a genuinely OBC candidate, a genuine OBC candidate. So the government is duty bound, constitutionally bound to protect the interest of the backward classes and the other reserved categories of the constitution. We have no blue-white person here, Lordship, from the government's perspective, whether the writ petitioner is manning that position or some other persons, but only thing is that if the post is reserved for OBC, a genuine OBC candidate should get it. Otherwise, there is no reason for government to act. When she joined in 2019 and was serving till 2021, till the complaint came, government has no animosity or nothing against this candidate. She was treated like any other candidate, but when something fishy was come out, and another thing that criminal aspect I am not taking
this honorable court to look into that aspect. That aspect is also very much clear because creamy layer, if we have to give the OBC benefit, then they should fall under the creamy layer. And creamy layer says that the minimum maximum income in a annual income of the family should be 8 lakhs. Non-creamy layer, only non-creamy layer will get. So her father and mother, both her father is a doctor and mother is a father now retired. Even now, with the pensioner benefit is much more than 8 lakhs. And the mother, she is still a state government class 2 employee. So that is a different aspect, but we are on the certificate. Now, next judgment, Lordship, which I'd like to place. Mhm. Good, simple. 1994 1 SCC phase 1. That's okay. I'm sorry, Lordship. I'll come to this judgment at the last. Then 2019 10 SCC phase 166.
166.
Lordship.
Paragraph.
Yes, paragraph 28, 29, 30. Requirement of the vigilance cell report. Paragraph 28. This is Maharashtra matter. District Collector Satara and another versus Mangesh Nipruti Kashid. I would like to come to paragraph 23 first. We may note that there are 3 kinds of writ petitions filed before the High Court. The first set of writ petitions were those who intended to participate in the ensuing election of local government, even though they did not at the stage have a caste validity certificate. The prayer was for relaxation of the condition to produce the caste validity certificate at the time of scrutiny, which had been made mandatory, though the caste certificate once issued was to remain valid for all purposes. The second set of writ petitioners were those whose caste certificate were invalidated by the scrutiny committee, and they sought for to challenge the decision with a direction to the returning officer to allow them to participate in the ensuing election. The third set of petitioners were those who challenged the caste validity certificate granted to the candidates who were party respondents in both writ petitions on the ground that the certificates were obtained by fraud, with a prayer for direction to the Election Commission to reject the nomination papers of such candidates. The impugned judgment has been rendered in the context of the third set of petitioners. The certificates in question were alleged to have been obtained without vigilance report and within a very short period of time would be apparent from the chart aforesaid. Then the Honorable Court, because the law has been framed on the basis of Madhuri Patil, that composition of the scrutiny, we have done it here. Now requirement, what is the importance of this vigilance cell report? In our case, the first vigilance report was there, therefore the Honorable Court relied upon it. Now we have come to know that the original vigilance report was not proper. Now, what the vigilance cell has to do, paragraph 28. The second part of the challenge relates to the requirement of verification of the certificates by the vigilance cell. This was provided to be mandatory in terms of the judgment of Madhuri Patil's case. The enormity of problem faced by the High Court through multifarious petitions arising over the unverified issuance of such certificate possibly persuaded the High Court to lay down stricter norms in this behalf. However, and as implemented for the interim period in questions, the input from the vigilance cell was obtained only selectively. Under the 2012 rules also, the requirement is not mandatory, but whatever the scrutiny committee feels it may solicit a report of vigilance and query.
We have, however, no hesitation to emphasize the importance of proper verification of such certificate to be issued, and the exercise of issuance of the certificates cannot be a casual one. The scrutiny committee constituted to issue the validity certificate must thus, at the slightest doubt, take the assistance of the vigilance cell to ensure that the non-entitled persons do not get benefited at the cost of entitled persons. We have no doubt that this is a process which will be so followed under the 2012 rules. Here we have no rules, but the OM and the principles are there. The matter, however, cannot rest at this because of the existence of power and exercise of two different aspects. The view adopted by the High Court appears to us have been in the context of manner of exercise carried out by the scrutiny committee in the given situation, and the casual manner with the assistance of vigilance cell was sought, or rather not sought. On these aspects, we are complete agreement with the view of the High Court. The exercise carried out in the interim period between 2011, 2011, when the notification was issued, and 31/8/2012, when the rules were notified, leaves us that the High Court with grave doubt, and we are of the view that no proper exercise could have been carried out or was carried out given the time frame within which the caste certificate was issued. The objective was clear: to somehow facilitate as many people as possible as soon as possible to contest the election. The troublesome aspect is that the validity certificates are not only valid for the election, but also for subsequent elections. They are not only valid for educational purpose, except for some cases so restricted, but also for all other purposes. These validity certificates can possibly become the basis of issuance of further certificates to their legal years. Thus, we have no doubt that the exercise so undertaken cannot be upheld, has to be quashed with the direction to carry out the aforesaid exercise afresh. So here also a fresh inquiry was directed regarding those verification reports. So my humble submission is that there is no bar if the situation so demands.
There are 32 you're missing out.
Lordship,
There are 32.
may I read it? We have appreciated the problem aforesaid and are thus of the view that the fresh exercise has to be undertaken within a period of 6 months from today, that is so and so. Till this exercise is completed, the existing certificate for the interims would hold good. So till now she is holding the certificate, the earlier one, which has been upheld by this honorable court. We are not touching it.
Read further.
The exercise would have to be undertaken in respect of all the certificates except those cases where the validity certificates were issued after verification by the vigilance cell. We may, however, hasten to add that in view of the case pointed out to us, where the vigilance cell opined otherwise and yet a valid caste validity certificate has been issued, the exercise may be carried out afresh. Thus, wherever there is an adverse report of the vigilance cell and yet caste certificate has been issued to the exercise has been carried out afresh, it may be added that those whose caste certificates were rejected by the caste scrutiny committee without any vigilance inquiry may be given the right to appeal against such rejection as per so and so. So not on the ruling part, but what I am to emphasize is that
When there is a vigilance report adverse,
yes,
then you have to carry out the exercise.
here the first report is in the favor. That is what the honorable court applied because of Madhuri Patel. Now we have an adverse report. In that situation, therefore, the scrutiny committee has issued the SOCUS notice. So inquiry is now going on. So there is, in my humble submission, it is not that one report has come that is to be considered as sacrosanct for all time to come. So many
So
amendments
then-
have taken place, so many reviews have taken place. Of the
Fraud and forgery is alleged,
yes,
then the restrictions on Madhuri Patil will not apply.
absolutely, Lordship. Now, fraud and all these misdeeds are very crystal clear. And this honorable court, just like the government, cannot close his eyes now because we have brought all the facts. Therefore, the division bench came to a situation that whether we should go or you should take the appropriate course. In review, suppose the review was allowed, even the second findings would remain unverified, untested. because it has to be tested as per the guidelines that the scrutiny committee will give them the opportunity to lead evidence. Suppose our inquiry officer have come to a conclusion that she have not practiced the traditions and customs of OBC. That is our finding. But if she is satisfied, if she convinces the scrutiny committee by leading evidence that she had adopted a life of OBC community, and also that she was staying with the maternal house, then she will have a good case. But for that, she have to lead evidence, and our evidence is contra. So next judgment, Lordship. So 2023, 16 SCC, page 415. আৰু বেছি মোক দেখাই থাকে আমাৰ হেৰিয়ে portfolio lead কৰিব লাগিব evidence. Here paragraph 28, 29, 30, 31. 2023, 16 SCC, 415, 3 judges bench of the Honorable Supreme Court, Maharashtra Adivasi Thakur Jamaat
Paragraph.
versus 28 to 31. The affinity test. So here, how the test has to be conducted, affinity test, then how the Supreme Court, the Caste Scrutiny Committee performs quasi-judicial function. So that is a quasi-judicial authority sort of. So these 4 paragraphs, Lordship, I am not reading 28, 29, 30. I'll come to 31. We must note here that this court was dealing in the same decision with cases arising from the state of Madhya Pradesh, where there was no statute in existence which covered the field occupied by Madhuri Patil's case. Therefore, observations made in the same decision are in the context of the power of the scrutiny committee ordered to be created under the decision of Madhuri Patil. In Dayaram and J. Chitra, this court has not dealt with the 2020 Act or similar enactments applicable to any state. On a conjoint reading of the 2000 Act as well as the SC and ST rules framed thereunder, it is impossible to conclude that the scrutiny committee discharges only administrative function. The scrutiny committee under 2000 Act has been entrusted with various powers of the civil code under the Code of Civil Procedure 1908. The powers include a power to enforce the attendance of any witness, to receive evidence, affidavits, to issue commissions of the examination of witnesses or documents. The scheme of 2000 Act and both the SC and ST rules provide for scrutiny committee holding the inquiry of the caste claim of the applicant if necessary, after examining the applicant on oath, recording the evidence of witnesses and calling for documents and records. The scrutiny committee is expected to record reasons for granting and rejecting the prayer for issue of caste validity certificate. The scrutiny committee has for all trappings of a quasi-judicial authority. So the present so-cause notice was issued by the director requesting the writ petitioner to appear before the scrutiny committee to give her side of her story. Now, next judgment, Lordship, is 2012 3 SCC, page 400. So 2012 3 SCC, page 400. Here I would like to read out, Lordship, paragraph 55, which will be very much relevant for our purpose. Paragraph 54 and 55. Here it is a case of intercaste marriage. So in that situation, how the opinion is to be given? May I read it, Lordship? Paragraph 54, 55.
Where one person is reserved and the other is not.
Yes. On the basis of OM has also been issued, which I have annexed and I have placed also.
You are referring to paragraph?
54 and 55. In view of the analysis of the earlier decisions and discussions made above, the legal position that seems to emerge is that in an intercaste marriage or marriage between a tribal and a non-tribal, the determination of the caste of the offspring is essentially a question of fact to be decided on the basis of the facts adduced in each case. The determination of caste of a person born of an intercaste marriage or marriage between a tribal and a non-tribal cannot be determined in complete disregard to the attending facts of the case. In an intercaste marriage or marriage between a tribal and non-tribal, there may be presumptions that the child has the caste of the father. These presumptions may be stronger in the case where the intercaste marriage or marriage between a tribal and a non-tribal, the husband belongs to the forward class. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by the mother who belonged to the scheduled caste, scheduled tribe. By virtue of being the son of a forward caste father, he did not have any advantageous start in life, but on the contrary, suffered the deprivations, indignities, humilities, and handicap like any other member of the community to which her mother belonged. Additionally, he was always treated as a member of the community to which her mother belonged, not only by that community, but by the people outside the community as well. So these are the aspects. These are the evidences the representative have to lead before the committee if she have to take advantage of her mother's caste. In our case, we have very clearly established one thing, that she has not suffered any deprivation, any indignities, any humilities or handicap of OBC. She was always having the opportunities to have her education in the front-ranking institutions from the preliminary or elementary stage to her higher education. She studied in one of the best missionary school in Jorhat, studied her higher studies in Cotton College and post-graduation also in Cotton College. She was living one part of her life in Jorhat in the most posh locality. That also has been found out in the second inquiry report. And she also stayed in Guwahati in her father's paternal house in Silpukhuri. All these will come to only a single conclusion, that she was in no manner deprived of her benefits of being a forward class person. That means her father's status. Number two, she have to prove that she only stayed with her mother and father was not in the scene at all. This is the finding in the first report and the submission of the senior counsel before the division bench also, that she all along stayed with the mother. Now, in our final inquiry report, it has come out that she was always staying with her parents. The father stayed in Jorhat not because that father is going and staying in her mother's place. No, they have a joint property. And that has been corroborated by all the statements of the family members. In our report, we have from whom the statements were taken, everything is given. So it is not a case of deprivation, or she is singly living with the father. And if we take a cue from that notification of the central government notification. Central government. The notification issued in respect of is child living with a single parent, that has also been issued by the central government. I'll just yes, 3/10/2019, page 336, issued by the Ministry of Social Justice and Empowerment and Department of Social Justice and Empowerment, 3rd October 2019. It was issued by the director of the department to all the chief secretaries of all state governments and union territories of the country. Caste certificate, caste status of offsprings of separated, divorced, and single women. I am directed to say that the comprehensive legal position about the status of offspring born to couples where one or both the spouses are members of scheduled caste or scheduled tribe was circulated by the ministry dated 21/5/1977. It has been represented to this department that the said guidelines are silent regarding caste status of offspring of separated, divorced, or single women. That is, whether the caste certificate can be issued to the children of separated, divorced, and single women on the basis of caste of her mother, absolutely covering our case. The Supreme Court in Ramesh Bhai Dabhai Naika, which I have just placed, held in an intercaste marriage or a marriage between a tribal and that I have just read out, Lordship, paragraph 55. 3. GNCT of Delhi instruction on issuance of caste certificate inter alia required the applicant to produce a caste certificate of a relative from the paternal side. This instruction was challenged in the Delhi High Court in the case of Rumi Chaudhary versus Department of Revenue, Government of NCT of Delhi. The Honorable Court in its order dated 14/8/2019 inter alia held that the practice of issuance of caste certificate based on the caste of father is not without exceptions. In certain cases where it is established that the children have grown up in a notified community or tribe and have suffered all the disadvantages and deprivations belonging to such community, the office order could not come in the way of issuance of caste certificate certifying that the applicants belong to the caste of their mother. In view of above observations by the Supreme Court and Delhi High Court, where it is established that the child has been brought up in the surroundings of a notified community to which the mother belongs to and has suffered the deprivations, indignities, humilities, and handicap like any other member of that community, and he or she was always treated as a member of mother's community, not only by that community, but by the people outside the community as well, then such a child of separated, divorced, or single woman has to be treated as a member of the scheduled caste community and would be entitled to receive benefits as such. However, each individual case will have to be examined in the light of existing facts and circumstances of the case. It is requested that these instructions be circulated among the authorities empowered to issue scheduled caste certificates. So, in the present proceedings before the scrutiny committee, if she is able to satisfy that she had suffered all the indignities, disadvantages of OBC community, and she was secludedly and living in that community, in that case, the scrutiny committee will have to follow this notification based on the guidelines of the Supreme Court as well as the Delhi High Court. But living in a prime locality in Jorhat, living with her parents, living with her father, she cannot take advantage of this notification. We have to establish that the father and the mother are not living together. And our inquiry officer found that they were all living together. Their submission before the division bench, in paragraph 4 of the division bench judgment, the senior counsel on behalf of the petitioner said that she is living with the mother. So they want to hide the father's existence. And father, what he is doing, he is also trying to get a OBC certificate. In that situation, the only course of action for the state is to issue a fresh notice to call her for a fresh inquiry where she has to participate and establish her case to contradict the findings or rebut the findings of the second inquiry report. So we are following the principles of natural justice based on all the laws, and the law also says that if the earlier inquiry report is perfunctory, improper, or obtained through fraud, then second inquiry is permissible. 1994 1 SCC page 1. paragraph 6. SP Chengal Varia Naidu versus Jagannath.
Page number?
Page number 1. 1994 1 SCC page 1.
Right.
Paragraph 5 and 6. 6. Paragraph 6, Lordship. So what is a fraud? The facts of the present case leaves no manner of doubt that Jagannath obtained the preliminary decree by playing fraud on the court. A fraud is an act of deliberate deception with a design to securing something by taking unfair advantage of another. It is a deception in order to gain by another's loss. So in our case, the genuine candidate is deprived. It is a deception in order to gain by another's loss. It is a cheating intended to get advantage. Jagannath was working and so and so. Now leaving few lines. Then without disclosing all these facts, he filed a suit in the partition of the property on the ground that he had purchased the property of his own behalf and not on behalf of Chunnilal. Non-production and even non-mentioning of the release date of the trial. So this is basically the facts of that case. So in this case, a fraud is an act of deliberate deception with a design of securing something by taking unfair advantage. And it is a deception in order to gain by another's loss. So in our case, what is that deception? What is that misleading misrepresentation? To give the impression that the mother and father are separately living. That is one. Number two, if we look at the affinity test and all, they have to show that all their family members are having that certificate. The brother is a general candidate studying higher studies. The father, what he is doing? He retired, he was a government servant, and in 2019, he also procured a OBC certificate. So this is a deception, this is an act of fraud. Had it been a singular case, the father tried to get an OBC certificate, it has nothing to do with the case. But here, we see the connection, the chain of events. The mother obtained a OBC certificate in November 2019. The father obtained in 2019 March when the inquiry was going on. If the father tried to obtain an OBC certificate in 1994 or at the time of his service, things would have been different. But here, all these things are done to mislead the direction of the inquiry. So he procured OBC certificate. Now he is facing criminal prosecutions for that. The mother, there is no doubt she is an OBC, but she have never procured a OBC certificate. So in 2019, she procured it. The brother till now has not done it. She has done it in 2006. And when the inquiry officer went to that office, they said, we have burned all the records up to 2006. From 2007, if you need any record, we can give. The manipulation to the DC office.
When was the certificate?
Issued in the month of November 2006.
Which is now not available.
Not available. Why it is not available? That can be another scope of inquiry. But we'll not go into that part. But the thing is that if this lady, Monsoon Borkakoti, establishes that she fulfills all the requirements as per the central government's notification based on the Supreme Court judgment as well as Delhi High Court judgment, she is entitled. But for that, she have to establish. Earlier round of inquiry, all these things were overlooked. Completely overlooked. The vital fact that the father and mother are living together, and the inquiry officer says he got married to a lady at Jorhat hailing from Koch OBC community and resided at matrimonial home. It was not a matrimonial home. It was a parental home. Wherein Monsoon Borkakoti was born on 12/4/1990. Why the father is staying there? He has his job, his area of operation.
All right.
And also the finding of the first round that Monsoon Borkakoti stated, so she gave a statement to the officer, education at Jorhat and accepted customs of Chaos community. Yes, she studied one part of her education in Jorhat, but enquiry was done in 2019 when she had completed her higher studies in 2015. So she deliberately deprived or suppressed the information that from 2009 to 2015 she studied in Cotton College and she stayed in Silpukri. Those vital facts were not unearthed by this gentleman, the enquiry officer.
Yes.
So, in that situation, so committed fraud, and also, if I am allowed to place paragraph 13.5 of Madhuri Patil, what the Vigilance Committee has to do. Paragraph 5 of paragraph 13 of the Madhuri Patil's case, 1994, 6 SCC, page 241. May I read it, Lord?
Yes.
Each director should constitute a vigilance cell consisting of senior deputy superintendent of police in overall charge and such number of police inspectors to investigate it into the social status claim. The inspector would go to the local place of residence and original place from where the candidate hails and usually resides, or in case migration to the town or city, the place from which he originally hailed from. Pausing here for a moment, the first report has not indicated that he visited Silpukri. He has totally bypassed that part. Next, the vigilance officer should personally verify and collect all the facts of the social status claim by the candidate or the parent or the guardian as the case may be. He has not done it. He should also examine the school records, birth registration, if any. So he has not done the school records verification, neither the college records verification, nor the birth registration. He should also examine the parent, the guardian, or the candidate in relation to their caste, etc., or such other persons who have knowledge of the social status of the candidate and submit a report to the director together with all particulars as envisaged in the pro forma, in particular of the scheduled tribe, relating to their peculiar anthropological and ethnological traits, deities, rituals, customs, mode of marriage, death ceremonies, method of burial of dead bodies, etc., by the caste or tribe or tribal communities concerned, etc. So he has relied upon other Supreme Court judgment, but he have miserably failed to follow the procedures and the verticals he have to look into in his enquiry as per paragraph 5. That is why I'm submitting that the enquiry report submitted in October 2019 is a sheer example of a perfunctory enquiry and an improper enquiry. I'm not saying that he has committed any fraud. The fraud has been committed by the writ petitioner's family and the writ petitioner. But he has not discharged his duty as per the requirement. In that situation, Lordship, we have every right and every reason, without any arbitrariness, without any illegality, without any biasness, to look into the facts afresh. So in that view of the matter, in my humble submission, the challenge to the show-cause notice and the enquiry conducted on the basis of the 26 December's report, in my humble submission, is properly legal, reasonable, and call of the duty of the government. In that view of the matter, this writ petition is liable to be dismissed. I am highly obliged for giving me a patient hearing also for 3 days. Deeply obliged.
Yes.
Like to give us first reply on Tuesday, madam.
No, Tuesday is a motion day.
And next week has been declared as a motion day.
We'll have it after reopening if required. What else? Or we can have it tomorrow if we can squeeze out.
Actually, my lord, the senior counsel K.N. was assisting on lordship. So he's traveling to Itanagar today. So today and tomorrow he is not.
We'll have it after immediately.
I have no difficulty. Only thing is that Lordship have recorded it fine. Otherwise, I have to repeat my argument. Then it is fine, Lordship. I wanted to
We are
complete
only
it as soon
keeping
as,
it for their reply, that's all.
yes,
Otherwise, we have heard, we can
Lots.
close the matter today also.
Lordship.
But you are good to give a reply if you want.
My lord, my instruction is that since
So therefore, we'll keep. it
No,
on
no,
the
no
matter.
difficulty, Lord.
16th or 17th or
Could it be any day from 21st onwards, Lordship? That week I am not available. I'll be back in on 21st. 22nd,
22nd.
Lordship,
July.
July.
Heard counsel for the parties, Mr. Abhijit Saike, learned Advocate General for the state, has concluded his arguments. Counsel for the petitioner seeks liberty to submit in rejoinder. That will be listed again on 22nd of July. That's part of it.
I'm deeply obliged, Your Lordship.
The last occasion, my lord, I had made my submissions. Just to reiterate, my lord, this application. Hearing from the hearing of the hearing of the hearing of the now get
Yes,
The issue here is, my lord, regarding the notional seniority and other service benefits on reinstatement in service. Lordship, the petitioner was serving as a constable in the Central Reserve Police Force, and he was terminated from his services in the year 2009. Lordship should find the order of this honorable court by which he was reinstated. At page 24 is the relevant portion, or it starts at page 16. At page 24 is the relevant portion. Thus, it is evident that the procedure laid down by the apex court in the case of Kumari Madhuri Patel Supra has not been followed.
24.
Page 24, my lord. Starts at page 16, the order. The relevant portion at page 24. Para 34.
Yes.
Thus, it is evident that the procedure laid down by the apex court in the case of Kumari Madhuri Patel has not been followed in the present case, which has vitiated the decision-making process, culminating in the decision to remove the petitioner from service. Accordingly, in the light of decisions made above, the impugned order of penalty dated so is as affirmed by the appellate authority cannot be sustained and are hereby set aside, and petitioner is directed to be reinstated in service without any back wages. The respondent, Union of India, went up in a writ appeal. The writ appeal order starts at page 25. Lordships would like to have page 27. Para 8. The writ petitioner was recruited in the year 2003 against an open category vacancy and not as an ST category candidate, and nothing is brought on record by the appellant to show otherwise. Hence, we decline to pass any interim order in the appeal. In other words, the appellants are required to reinstate the constable in terms of impugned judgment dated so and so. This was an interim order passed. Now, the final, they took up the matter of interim orders to the Honorable Supreme Court at page 29. Interference was declined. Then they passed an order at page 31, reinstating me during pendency of the writ appeal. Here, if Lordship finds at page 32, the last paragraph, in view of the above, I, the undersigned, hereby set aside the punishment of removal from service imposed upon so-and-so by Commandant 84 Battalion by order dated 9/6/2007, and he is hereby reinstated into service with immediate effect in consonance with the order dated 25/1/17 passed by the division bench in writ appeal number 280 of 16. The reinstatement of Constable so-and-so is conditional subject to the outcome of writ appeal 280 of 16. On his reinstatement, he is posted to 84 Battalion CRPF at Chhatha, Jammu. He is also directed to report on duty in 84 CRPF within 15 days of receipt of this order. He is not entitled for back wages from the date of removal from service till reinstatement as held by the single bench of the Honorable High Court of Guwahati by order dated so and so. The intervening period, that is the date of removal from service till reinstatement, is treated as period not spent on duty. However, the above period is condoned for the purpose of pension under Rule 25. This is where the first grievance starts. when they say that it will be a period which will be not treated as on duty.
What was the direction of the single judge?
Single judge direction, Lordship, would find at page 24, para 34, the last line. Petitioner is directed to be reinstated in service, but without any back wages. So all that was held back was the back wages part.
Yes.
It was only when in the writ appeal, the interim orders were refused and they went up to the Supreme Court against that order, then thereafter they ordered a reinstatement for me. However, treating the entire period to be not spent on duty.
If back wages is not granted,
My lord.
then yes, can it be considered to be a period spent on?
Yes, for all other purposes, for the notional part, it can be there because the back wages, for payment of back wages, as held by Dipali Kundu Survasi, if a person does not pray that he remained unemployed and he suffered, then back wages will not come in ipso facto. But the other part, the continuity in service, reinstatement, the very definition is, I am put back to a place where I would have been if that impugned order did not come into existence. On the last occasion, my lord, I had read out that portion of the law. Then at page 34,
You are referring to which judgment?
my lord, I refer to one judgment of Dipali Kundu Survasi. Where, my lord, two things were discussed. One, what is a reinstatement in service? And thereafter, how the interim period is to be calculated.
Yeah.
Huh? Section to hold 2013 10 SCC 324. 324. 324. The second grievance has come in at page 34 when the commandant following the orders of the Director General.
No, you can actually paragraphs of the judgment.
No, like that. Para 16, my lord. The word reinstatement. The word reinstatement has not been defined in the Act and the rules. As per Shorter Oxford English Dictionary,
Para 16 of
my lord, the judgment, my lord, in my copy it is para 16. Starts with the word.
It was in SCC namely one of these. Supreme today.
In Supreme today.
University.
What copy this? No, SCC.
this is 2013.
2013 10 SCC 324.
324, yeah. What is the first sentence?
The word reinstatement has not been defined. SCC
Yes. Okay.
The word reinstatement has not been defined in the Act and the rules. As per Shorter Oxford English Dictionary, the word reinstate means to reinstall or re-establish a person or a thing in a place, station, or condition to restore to its proper and original state. To reinstate afresh, and the word reinstatement means the action of reinstating, re-establishment. As per so and so, the word reinstate means to reinstall, to re-establish, to place again in a former state, condition, or office. To restore to a state or position from which the object or person had been removed, and the word reinstatement means establishing in former condition, position, authority, reinstatement of a deposed prince. As per Merriam-Webster dictionary, the word reinstate means to place again, as in possession or in a former position, to restore to a previous effective state. As per Black's Law Dictionary, reinstatement means to reinstall, to reestablish, to place again in a former state. Para 17 in my judgment. The very idea of restoring an employee to the position which he held before dismissal or removal or termination implies that the employee will be put in the same position in which he would have been, but for the illegal action taken by the employer. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot be easily measured in terms of money. With the passing of an order which has the effect of severing the employer-employee relationship, the latter's source of income gets dried up. Not only the concerned employee, but his entire family suffers adversities. The deprived of source of sustenance. Children are deprived of nutritious food and all opportunities of education and advancement is life. Now, if we come to the first part again, the very idea of restoring an employee to the position to which he had held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been, but for the illegal action taken by the employer. Now, so far as the entitlement of back wages in such circumstances come, if Lordship kindly comes to the paragraph 33 of the judgment, why the back wages and the other notional benefits would be severed from each other. Para 33, Lordship finds, starts with the word, the propositions which can be culled out. Around 7 propositions in small Roman numericals are given towards the end.
Yeah.
The propositions which can be culled out from the aforementioned judgments are: in cases of wrongful termination of service, reinstatement with continuity of service and back wages is the normal rule. The aforesaid rule is subject to the rider that while deciding the issue of back wages, the adjudicating authority of the court may take into consideration the length of service of the employee, the nature of the misconduct, if found proof against the employee, the financial condition of the employee, and other similar factors. 3 is important. Ordinarily, an employee or workman whose services are terminated and who is desirous of getting back wages is required to either plead or at least make a statement before the adjudicating authority or the court of first instance that he was not gainfully employed or was employed on lesser wages. If the employer wants to avoid payment of full back wages, then it has to plead and also lead cogent evidence to prove that the employee was gainfully employed. So once, if I had paid for back wages, it was upon the petitioner to have shown that he was not gainfully employed. Otherwise, both in the writ appeal and in the writ petition order, when the order of termination is found to be bad on 2 counts. 1, the procedural defect, Kumari Madhur Patel not being followed, and on merits, I was never appointed as an ST category candidate. The moment a matter is set aside on merits, even the fundamental rules say that when a termination order is set aside on merits, I am entitled to everything, including back wages. But this honorable court, the learned single judge, did not allow me back wages, and I never questioned it in any manner. Here, the entire issue is at page 13 again, at para 17. How was I supposed to be reinstated? The para that I just read at para 33 says, it is with continuity of service for everything, including back wages. I do not pray for back wages. That continuity has to be there, and therefore they cannot treat that period to be not spent on.
You're asking for your seniority.
The pay fixation would come in.
Everything.
The pay fixation will come in. What my immediate junior is drawing, I draw above him. The seniority that I was supposed to maintain. Those two things, and what they have given is the continuity for the period of for the purpose of pension. That remains, there is no problem. But the other 2 part, when I miss out on a wrong termination, is the issue.
Lordship, he had not challenged the back without back wages, Lordship. He had not challenged the initial order without back wages, Lordship. The order was of the single.
Back wages is denied, but
Denied.
Yes,
Does it
Lordship,
also affect to deprive him of the other benefits?
if he not challenge that order, Lordship, here is the judgment, Lordship is, it was 2005 6 SCC. If he doesn't plead and challenge, Lordship, he cannot get Lordship.
He's not asking for back wages.
Not back pages and seniority also, Lordship. Kindly see this order, Lordship, relevant page from paragraph 5, Lordship. Para 5, Lordship. Continuity of service and whether notional increment are to be given to the employee for the period for which he is not in service in absence of specific direction in this regard. At this stage, we may notice the operative portion of the award of the labor code is the dismissal of the petitioner from service cannot be sustained and he is be reinstated but without back wages. We have heard the counsel for the party now, Lordship. It is contended by the counsel for the appellant that it is well established principle of labor and industrial law that upon setting aside an order of termination, the workman is reinstated as if the contract of the employment originally entered into and had been continued. The council further contended that in such cases, the terms and condition of the contract, which was obtained then when the workman was in the employment of the employer prior to the wrongful dismissal, which has been set aside, continue to govern the relationship between the parties and the workman continues to be in the employment of the employer on the terms and condition of the contract. According to the council, denial of consequential relief is an exception unless such denial has been specifically spelled out. Otherwise, the natural and consequential relief must follow. Council would further contended that in the given facts, this would be competent enough to mold the relief as the workman has reinstated after more than a decade. In our considered opinion, the argument advanced by the council is not tenable in law. In the view taken by the court in the recent decision in the case so, this court had occasionally to deal with the incidental controversy and crystallized the point of law. In that case, the respondent was a conductor in the employment of the appellant APARCTC. He remained absent from the duty so and so, and again between so and so to so and so, a department inquiry was initiated
Where is
against.
the judgment of Narsagaon, which is repeated, relied upon?
Lordship, 2003 2 SSC 212. Hmm. Five, 60, 36. The paragraph 9 is quoted in this judgment, Lordship. The principal law in no more res integra, the court as in singly crystallized principle of law in para 9 of the judgment. Para 9 is quoted here, Lordship. We find merit in the submission so made. There is a difference between the order of reinstatement accompanied by a simple direction for continuity of service and a direction wherein reinstatement is accompanied by a specific direction that the employee shall be entitled to all consequential benefits, which necessarily flow from the reinstatement or accompanied by a specific direction that the employee shall be entitled to the benefit of the increments earned during the period of
In your
absence.
case, sorry, in your case, Mr. Mukhtar, what was the allegation?
My lord, that the caste certificate, the tribe certificate that I had submitted was fake and that I had taken the appointment.
It is not a case of unauthorized gift.
No.
No.
Duty cannot claim the benefit of increment notionally earned during the period of an unauthorized absence in the absence of a specific direction in the regard and merely because he has been directed to be reinstated without the benefit of continuity in service. Reverting to the fact of the case at hand, as already noticed, the labor code specifically directed that the reinstatement will be without back wages.
there is no specific direction that the employee would be entitled to all consequential benefits. Therefore, in absence of a specific direction in that regard, merely because an employee has been directed to be reinstated without back wages, he cannot claim a benefit of increment notionally earned during the period. And the judgment cited by my friend here also, there is specific plea has to be made there.
Or back pages.
Other consequential benefits are also there.
Yes.
That's all. We have not challenged that single bench order. So therefore, Lordship, we cannot claim Lordship. My humble submission.
Andhra Pradesh Road Transport नहीं तो
हाँ?
Andhra Pradesh Road Transport जा रहा है
हाँ?
नहीं
बिल्कुल।
अपील करी ना तो भाई यार डिस्कस कोई सी best of my knowledge it was discussed in discuss yes Andhra Pradesh Road Transport Corporation Jairam Reddy है ना
And in the final order, Lordship, his the order till the above period is condoned for the purpose of pension also given to him. For that, it
But there is a case of absence from service.
Okay, but the absence from service is
The
there. but-
finding of the court, both in the earlier judgment which is referred here,
Lordship.
which is that judgment. Narsagaon.
Narsagaon, 2003.
So Narsagaon judgment was that there was unauthorized absence.
Absence.
So he did not attend the duty, he was not entitled to back wages.
Here also, Lordship,
I was
during,
kept out of service.
during,
Not a case of unauthorized absence.
not unauthorized, but he was not in service at that point of time. Up to this.
Para 11 of
there
the
is.
judgment.
Yes, I've seen, Lordship.
Para
Revert-
11.
Reverting to the fact of the case, and I already noticed the labor court specifically directed the reinstatement with would be without back wages. Here also, Lord,
No. Further,
there is no specific direction that the employee would be entitled to all consequential benefits. Therefore, in absence of a specific direction in that regard, merely because an employee has been directed to be reinstated without back wages, he cannot claim the benefit of increment notionally earned during the period when he was not on duty during the period when he was out of service. Here also, he was not in service.
what is the gap?
The gap I was thrown I was sent home in 2007 I was reinstated in 2012
12.
We are asking for 7 to 12.
Yeah.
7 to 12 the notional benefits now the concept that has been given by my learned friend in his judgment that is a 2005 judgment Dipali Kudu Survasi is 2010 and it specifically it deals with it that is what I was trying to show
So it deals-
latter judgment deals with it
But does it overrule?
yes
It overrules.
yes the concept is overruled Lordship would find at page para 32 the entire concept is overruled We may now deal, Lordship, right? We may now deal, is the paragraph starts.
Yes.
We may now deal with the judgment in JK Synthetics Limited and KP Agarwal and another in detail. The facts of that case were that the respondent was dismissed from service on the basis of an inquiry conducted by the competent authority. The Labour Court held that the inquiry was not fair and proper and permitted the parties to adduce evidence on the charges leveled against the respondent. After considering the evidence, the Labour Court gave benefit of doubt to the respondent and substituted the punishment of dismissal from service with that of stoppage of increments for 2 years. On an application filed by the respondent, the Labour Court held that the respondent was entitled to reinstatement with full back wages for the period of unemployment. The learned single judge dismissed the writ petition and the division bench declined to interfere by observing that the employer had willfully violated the order of the Labour Court. On an application made by the respondent under Section 6(6) of the UP Industrial Disputes, the Labour Court amended the award. This court upheld the power of the Labour Court to amend the award but did not approve of the award of full back wages. After noticing several precedents to which reference has been made herein above, the two-judge bench observed, there is also a misconception that whenever reinstatement is directed, continuity of service and consequential benefits should follow as a matter of course. The disastrous effect of granting several promotions as a consequential benefit to a person who has not worked for 10 to 15 years and who does not have the benefit of necessary experience for discharging the higher duties and functions of promotional post is seldom visualized while granting consequential benefits automatically. When courts and tribunals direct reinstatement, they should apply the judicial mind to the facts and circumstances to decide whether continuity of service or consequential benefit should also be directed. This part, JK Synthetics, is what he has read out just. Lordship will have Roman 7 of paragraph 33, the propositions.
Roman 7 of
The propositions, paragraph 33.
this.
This very judgment, my lord. What the paragraph 33 starts with, the propositions which can be culled out from the aforementioned judgment are. Then there are 7 small Roman 7, the 7 propositions have been laid out.
Referring to this Dibali Gundu.
Yes, yes. Towards the end, there are 7 propositions laid down in small Roman 7, small Roman numericals.
Right here, you are referring to 7.
7, Roman 7. The observation made in JK Synthetics Limited and KP Agarwal Supra that on reinstatement, the employee workman cannot claim continuity of service as a matter of right is contrary to the ratio of the judgments of the 3 judges' benches referred to herein above and cannot be treated as good law. That part of the judgment is also against the very concept
Which
of
are the 3 judges?
the 3 judge benches has been referred to.
Hindustan team.
Hindustan Tin Lordship will find at paragraph 18. Mary paragraph 18, my lord. A somewhat similar issue was considered by a 3-judge bench in Hindustan Tin Works.
Para 18.
Para 18 in my reference.
Let us go back to the facts of the case. Para 2.
The appellant was appointed as a teacher in Nandavan Vidya Mandir run by a trust established and controlled by the Bagade family. The grant in aid given by the state government, which included rent for the building, was received by the Bagade family because the premises belonged to one of its members, namely Sri So-and-so. In 2005, the Municipal Corporation of Aurangabad raised a tax bill of So-and-so by treating the property as commercial. Thereupon, the headmistress of the school, which was also the president, addressed a letter to all the employees, including the appellant, requiring them to contribute a sum of 1,500 per month towards tax liability. Appellant refused to comply with the dictate of the headmistress. Annoyed by this, the management issued as many as 25 memos to the appellant and then placed under suspension. She submitted a reply to each and every memorandum and denied the allegation. Education Officer Primary Zilla Parishad did not approve the appellant's suspension. However, the letter of suspension was not revoked. She was not even paid substance allowance in terms of the Maharashtra Employees' Pension. Read petition number so and so filed by the appellant questioning her suspension was disposed of by the division bench of the Bombay High Court by order dated so and so, and it was denied. It was declared that the appellant will be deemed to have rejoined her duties from 1437 and entitled to consequent benefits in terms of rule so and so, and the payment of arrears shall be the liability of the management. Paragraph 4 of the order read as under. Considering the order we intend passing, it is not necessary for us to deal with the rival contention of the parties. That will be for the inquiry committee to decide. In view of the apprehensions expressed regarding the inquiry being dragged on unnecessarily, it is necessary to safeguard the interests of the petitioner as well. In the circumstances, rule is made absolute. The inquiry committee shall conclude the proceedings and pass a final order on or before so and so. Petitioner shall be at liberty to have her case represented by Miss so and so. The petitioner shall appear for the first instance before the inquiry committee. The petitioner is entitled to the benefit of so and so, as specified in paragraph 11 of the order and judgment of the division bench in the case of Hamid Khan Nair. The petitioner shall be deemed to have resigned her duties from 14/3/2007 and entitled to consequential benefits that would flow out of the rule so and so. The payment of arrears shall be liability of the management. In the meanwhile, the management issued notice dated 28/12/06 for holding an inquiry against the appellant under Rule 36 and 37 of the rules. The appellant nominated Srimati so and so to appear before the inquiry committee, but Munde was not allowed to participate in the inquiry proceedings. Inquiry committee conducted ex parte proceedings and the management terminated the appellant service by order dated 15/6/2007. Appellant challenged the aforesaid order under section 9 of the Act. In the appeal filed by her on 25/6/2007, the appellant pleaded that the action taken by the management was arbitrary and violative of the principles of natural justice. She further pleaded that the sole object of the inquiry was to teach her a lesson for refusing to comply with the illegal demand. The management contested the appeal and pleaded that the action taken by it was legal and justified because the appellant had been found guilty of misconduct. It was further pleaded that the inquiry was held in consonance with the relevant rules and principles of justice. By order dated 26/2009, the presiding officer of the school tribunal, Aurangabad division, allowed the appeal and caused the termination of the appellant's service. He also directed the management to pay full back wages to the appellant. The tribunal considered the appellant's plea that she had not been given reasonable opportunity of hearing and observed. Now let us test for what purpose and for what subject inquiry was initiated, in what manner inquiry was conducted, which witnesses have been examined, and how injury was concluded. Inquiry was concluded. I have already demonstrated above that the starting point against this appellant is calling upon staff members' collection of funds for payment of tax dues of appealment. All the staff members have objected to this and joined hands together. Fact-finding committee have submitted its report, Exhibit 62, Report of Education Officer in regard to the proposal of appointment of administrator is at page 71. If we see issuance of memo by the headmistress, I observe that the language which is used to revengeful against this appellant. It seems that the attitude towards the appellant was of indecent, and I observe that the behavior of the appellant have also instigated headmistress for the same language of low standard used in the letter by imputing defamed language and humiliation of the appellant. If we see the memos, we can find some memos are of silly count, late for 3 minutes, query about examination, to which appellant could have replied when no examinations were held. Where is the question of getting inquiry by the parents in regard to the memo, in regard to the black dress, about issuance of so-called notice? Come a little bit down below. The tribunal then adverted, because this was only discussion. The tribunal then adverted to the charges leveled against the appellant and held. It is also demonstrated in the course of argument that permission was not granted per letter dated so and so of the education officer. So naturally, suspension of the appellant was in question. This is another aspect that on persuasion, appellant had been paid substance allowance. However, remaining substance allowance till today is not paid to the appellant, so there can be another ground for vitiating the inquiry. Then we discuss this. On the next page, the tribunal finally took cognizance of the fact that the appellant was kept under suspension from 14/11/2006, and she was not gainfully employed after the termination of her service, and declared that she is entitled to full back wages. The operative portion of the order passed in the tribunal reads as under. Appeal is allowed. Termination order issued by the respondent on the basis of inquiry report is hereby set aside and quashed. The appellant is hereby reinstated to her original post, and respondents are directed to reinstate the appellant in her original post with full back wages from the date of termination till the date of reinstatement. The respondent number 1 to 3 are directed to deposit the full back wages, that is, pay and allowances to the appellant from the date of her termination till the date of her reinstatement within 45 days. Appellant will be entitled to withdraw the above amount from this tribunal immediately after it is deposited. The management challenged the order of the tribunal in writ petition number so and so. The learned single judge examined the issues raised by the management in detail and expressed his agreement with the tribunal that the decision of the management to suspend the appellant and to terminate her service were vitiated due to violation of statutory provisions and the principles of natural justice. While commenting upon the appellant's suspension, the learned single judge observed, it has also come on record that the appellant was suspended by suspension letter dated 14/11/2006. The appellant made representation to the education officer. The education officer refused to approve suspension of the appellant as per his letter dated 22/11/2006. From careful perusal of the material brought on record, I find that there arose extraordinary situation to suspend services of the appellant without taking prior approval of the education officer. As contemplated under the rules, no doubt the management can suspend services of an employee without prior approval of the education officer. But for that, there should be extraordinary situation. However, in the facts of this case, nothing is brought on record to suggest that there was an extraordinary situation existing, so as to make the emergent steps of to suspend services of the appellant without taking prior approval of the education officer. It is also not in dispute that the education officer declined to approve suspension of the appellant as per his letter dated 22/11/06. Therefore, taking into consideration the facts involved in the present case, conclusion is reached by the school tribunal that the management of the petitioner school institution is dominated by the members of the Bagade.
This is overruled. This judgment is not overruled, but
The concept is.
the proposition which was laid down is in the same lines as in J.K. Singh. So this is impliedly overruled.
It's a very allegation against me that I had usurped the post of I had deposited a fake certificate and that I had usurped the post of an ST candidate.
Those are
That
not the issue here.
and
It has already been.
on two counts, what I'm trying to say is, if it was only procedural lapse, they would still have the liberty to go ahead and impose a punishment on me. But the very fact that I was not recruited as a ST category candidate, the charge fails. So my entire absence.
Even in these issues, it has already been interfered with.
Yes.
Side, the appeal, SLP, whatever has been. What happened to the writ appeal?
It was allowed.
Dismissed.
Oh, sorry, dismissed. It was dismissed.
It was dismissed.
That is what I read at page 27.
In terms of that single bench order, we have reinstated him. We will mention in the order, Lordship.
Your submission that the benefit of increment, etc., will be available appears to be contrary.
Yes.
You go through it and
Lordship.
press the court
Lordship.
if you want.
Lordship. Lordship is one time, Lordship. That
Otherwise, we are convinced
Lordship.
to allow the writ.
Immediately up.
Monday, Tuesday.
Lordship, immediately after vacation. Monday, Tuesday, I will not there.
Vacation, you'll forget everything.
On Friday, then Lordship. Then Monday, Tuesday, I will not be there.
Wednesday. Do it on Wednesday or Thursday.
Thursday, Lordship.
Thursday. List on. Is that sixth,
26.
for orders.
Lordship.
You mentioned the matter on 26th.
Lordship.
So that in case you have to submit anything, you submit. We'll close the hearing. Pass orders.
Bless.
Is this?
Here, my lord, the petitioner was initially denied appointment in the Central Reserve Police Force, and he approached this honorable court by filing a writ petition, which was allowed, and there were directions to give him appointment. If lordship has the first writ petition filed by the client at page 23. It starts at page 23. There were two writ petitions disposed of together. The second one was the petitioner 3025 of 2008. Their lordship should find at page 26 is the relevant portion. The to the second paragraph from below, I will read, my lord. In the above circumstances,
Page number?
26, my lord.
Hmm.
The second paragraph from below. In the above circumstances, and more particularly when the advertisement itself provided for 23 vacancies of constable driver, with categorization of 12 and 6 vacancies respectively in the above categories, I am of the considered opinion that the particular plea of reduction of post during remastering is not acceptable. If any such reduction was there after the advertisement or selection process, the respondents could have justified the same by producing the records and meeting the queries made in the aforesaid order dated 10/5/2010 instead of trying to substantiate their claim by filing additional affidavit without meeting the points. In view of the above, both the writ petitions are allowed, directing the respondents to take further process towards the appointment of the petitioners in terms of the advertisements and the vacancies notified therein. Let the entire exercise be carried out as expeditious as possible, preferably within 1 month from today. And this order was passed on 23/8/2010. The advertisement was of 11/4/2008. The appointment letter, Lordship finds the type copy at page 28 onwards, which was issued on 28th of October 2010. In the meantime, my lord, my batchmates come to be appointed in the year 2008 itself.
Yeah.
The claim of the petitioner here was for giving him the notional benefits of seniority and other notional benefits from the date when his batch was appointed to the force. He loses his service by 2 years because of the delay in the appointment. The representation which he had made was rejected by page 35.
I think there were some orders passed by this court or division bench of this court in
My lord.
respect.
My lord, in one of
That
the
is with
matters,
regard to pension, I think.
pension, Mukesh Chandra Bora and all are there, they'll be governed by the old pension scheme if the appointment process started prior to the coming into force of the new pension scheme. Here, my lord, I'll place relevant judgments.
No, this is what is your prayer here?
My prayer is that, my lord, my seniority or my date of appointment be reckoned, my notional benefits be reckoned from the date when my batchmates were appointed to the force without having to go through
You're
litigation.
not appointed?
Because I had to go through litigation, they said there were 12 posts for general and 6 posts for OBC. While making the appointments, I was selected. While making the appointments, they said the post had reduced. I approached this honorable court. This honorable court could not find any record. They could not place any record to show that the post has actually decreased. Therefore, this honorable court said that I had a right to be appointed on the posts advertised. And I was accordingly appointed. If that appointment...
But your appointment is not antedated.
No, no, no. The appointment letter is not antedated. But the Supreme Court law says that if there was no mistake on my part in the delayed appointment, and I had to go through a process of litigation to come into the services, then I will get the benefits of what my batchmates have notionally. I will not get the salary, I will not get anything, but the notional part has to come in.
You were not even a part of the force
Force.
for the service.
Yes. Yes. I was not a part of the force or I was not a part of the service because till that point of time, I was restrained by the respondents, an act which has been found to be illegal.
That is why.
That has been considered by the Honorable Supreme Court, my lord.
But because
Also by the division bench of this Honorable Court.
your appointment order was not antedated.
And it cannot be, my lord. It cannot be antedated.
If it cannot be,
But-
then how do you get your notional or benefits prior to a date that you were even a member of the service?
My lord, it will be notionally taken to be that I have been appointed on that day. It need not be antedated. Their act of giving me the appointment on a later date has been,
Examine your judgment.
my lord.
We'll examine the judgment.
Yes,
Lordship, here I request some time, Lordship. The affidavit is filed. Affidavit filed, Lordship, I request in the court.
Huh?
Here, after the vacations, Lordship, please.
After vacations,
No.
the request made by the London CPC.
May I, Lordship? Lordship, the petitioner was discharged from service on 25 March 2020, my lord, on the ground that he was a reported delay of 1,166 days, my lord. A reported delay in 1,166 days, my lord.
Delay.
Late, my lord. He rejoined his duty
Ah,
after 1,166 days, my lord. We have filed this writ petition, my lord, that the procedure has not been followed during the trial of summary Assam Rifle Court, my lord. What in the affidavit we have seen that more or less procedure has been followed. Even the discharge order, dismissal order has also been converted into the compulsory retirement, my lord. But thing is that, my lord, the petitioner was rejoined his duty in the year 2016, my lord. 9 July 2016, my lord.
what is your prayer now?
For reinstatement, my lord.
Reinstate.
Yes, ma'am.
You are being compulsorily retired.
Yes, my lord.
Hear it in the regular course.
My lord.
But
the
pleadings are complete.
Yes, my lord.
I heard counsel for parties issue rule. That will be listed for hearing in
My
the
lord.
month of August.
My lord.
This is 2020,
Yes, my lord.
right? August.
Deep your lordship.
Eleven, 12, 13.
May it please your lordship. Lordship, in this case, lordship, leading counsel Mr. Vijay Soikia sir is out of town today, lordship. Kindly, lordship, fix the matter on 22nd of July, lordship.
No, after vacation.
After vacation, lordship.
Yes, Mr.
मतलब after vacation on 24th मतलब July मतलब
We do.
Oh,
Why?
my
I'll
God.
fix a date.
मतलब yes please.
Otherwise, we are ready with the case.
Yes.
There's a mention made on behalf of the senior counsel.
No difficulty, Lordship. I should not. 24th, if it is not inconvenient.
24th. All right.
July.
What is the matter about?
Basically, a promotion policy was put to challenge, and there is an alternative remedy also, maintainability issue.
All right.
The issue is well settled by the Supreme Court and Delhi High Court also.
Maintainability is a
Yes.
question. Item 11, 12, 13, a request made by, on behalf of the hearing counsel for the petitioner that the other city. It stands deferred. It is still again. 24th of July. 24th.
Yes.
Lord. Mr. T. Sakia. Advocate General appeared.
Senior counsel. This is for the
Senior-
ONGC.
Yes, wins. Senior counsel for the respondent. Out of fair made. He's recording.
Highly obliged.
Thank you, sir.
May it please. My lord, the petitioner is asserting his promotional rights here. The service rule provides seniority cum merit. However, his junior has been promoted from the post of grade 4 peon to, my lord, LDA assistant. This is the hard ground of litigation. Apparently, there is a, my lord, arbitrary selection and appointment in favor of the private respondents.
Yes.
My lord, the petitioner is working as grade 4 peon, and lordship will find his appointment letter at Annexure 1, page 25.
You are claiming a right to be considered for promotion.
Yes. My basic
What are you
remark,
challenging here?
my lord, I am challenging denial of my promotion as well as supersession. So I have been superseded by a junior man.
Have you assailed them as parties?
Yeah, they have appeared, man.
So you are challenging the departmental CPC meeting?
Yes, madam.
Promotional orders?
My lord, yes, promotional orders we have annexed, that we have assigned, my lord. Private respondent orders. Lordship will kindly say, just one annexure will make it clear. Have annexed the relevant rules. Lordship will kindly turn to page 32 of my petition. The promotion is in question is from grade 4, that is peon to LDA assistant. So Lordship, the relevant rule is at page 32, rule 6, lower division assistant. I give Lordship got it.
32. Yes.
Yes, Lordship will come to rule 6B, small b. By selection on the basis of seniority come merit from amongst the grade 4 staffs of the district establishment concerned who have passed higher secondary or equivalent examination and have rendered at least 7 years of continuous service in the district establishment on the first day of the year in which selection is made. Now, note is very important, my lord. The proportion of vacancies to be filled up in any year according to clauses A and B of the sub-rule 6 of rule 6 shall be 90:10. That means 90% of the vacancies by direct recruitment, 10% by vacancies by way of promotion. And the eligibility condition was, my lord, higher secondary pass. However, subsequently, while amendment carried out on, my lord, in the year 2010, that is at Annexure 3, page 40, Rule 6 has been amended at page 41. The sub-rule B of Rule 6, now it is, my lord, graduation from the year 2015. And these impune promotions are of the year 2018. Major Lordship got it. 6B was amended in the year 2015, page 41. Now, in place of higher secondary, now it is graduation, my lord. And I am a graduate.
Where is the rejection order?
Yes, my lord. Lordship will kindly come to page 48, Annexure 8. Lordship, one more annexure, my lord. Lordship will kindly turn to the last page of the petition. Page 51.
Yes.
Last page of the petition, page 51, Annexure 10. My lord, serial number 13, the Tamal Bose is private respondent number 4 here.
Just 1 minute.
Yes.
Serial 13 and 14.
Yes, serial 13 is respondent number 4 and 14 is respondent number 5. And Lordship, in the last column, in respect of serial number 14, he is joined as peon 2210-2010 and I joined on 25/2/2010.
As direct recruit or promotion?
No, my lord, direct recruitment.
Direct recruit, number 15.
So he is junior to me, my lord.
I'll just rise for 1 minute and come back.
Yes, yes. was referring to the annexure 10 at page 51, last page, my lord.
Yes.
So serial number 13 is response number 4, and serial number 14 is response number
Out
5.
of these persons,
Yes.
how many are promotion? You are claiming the promotional quota,
Yes, both of them are promotion, my lord.
13 and 14.
And they have been promoted from grade 4 to junior assistant.
They are senior to you.
No, 13 is senior to me,
Ah.
but 14 is junior to me. In the in the feeder post. And my lord, serial number 15, Sri Kamal Sharma, he has expired on 24/9/2021.
He is not promotee.
No,
Was he a promotee?
yes, he was promoted as junior assistant on 1/10/2019.
All right. So you are saying that this post is vacant?
Yes. So the rejection order just now I have placed at page 48. It's self-contradictory, my lord.
No, but they mentioned only 2 orders, 2 posts.
Yes, that's why self-contradictory. But this is their own document.
Where is the rejection order again?
At page 48, my lord. Annexure 8.
Yes.
It does not tell you with the record.
Yeah, what is the stand of the respondents in the affidavit file?
My lord, now they say that, my lord, this is a finance taxation department, and the district establishment rules were, my lord, adopted by them. However, the
You are working under which department?
finance taxation unit 2, my.
Which rules govern your service?
Yes, my lord, this is the stand of the private respondents that the ministerial district establishment rules were adopted since there is no service rules in the department. However, the amendment part was not adopted. That's why their
The amendment parts?
the 2015 amendment by which the educational qualification has been amended from higher secondary to graduation, that part they have not adopted. That is their contention. However, by the second contention that the rules prescribes the seniority come merit, on that count also I am eligible, my lord. Either way, I am eligible. And I have been deprived. And this is the third round of litigation. Since 2018, I have been litigating.
Yes, Mr. Gogoi, any?
But so far as the promotion part is concerned, my lord, it is guided by one office memorandum at page 61 of the, my lord, affidavit in opposition filed by the respondent number 5, which is not part of the petition.
Yes, what does it say?
It says that, my lord, since there is no service rules on 6th of April 1999, this office memorandum was issued to guide the, my lord, promotion from grade 4 to grade 3. So it says, my lord, representation for promotion to the post of LD assistant cum typist are often received from grade 4 employees of different offices under this commissionerate. It is clarified for the benefit of all heads of offices under this commissionerate that they themselves have to dispose of such representations, and the Commissioner of Taxes cannot pass an order in respect of such claims for promotion in their offices. The head of the offices will have to follow the following procedure. It's the procedure that has been laid down and not some adoption of a rules. The heads of the offices will have to follow the following procedure in the method of promotion of grade 4 to the post of LD assistant cum typist. As there is no service rules for establishment of the subordinate offices under this commissionerate, the Assam Ministerial District Establishment Service Rules 1967 is generally followed by the subordinate offices for guidelines wherever necessary. According to the provisions of Clause B of Sub-Rule 6 of the Rule 6 of the said rules as amended by Government Notification Number to ensure dated 17/3/94, 10% of the vacancies of LD assistant in any year is to be filled up by selection on the basis of seniority cum merit from amongst the grade 4 staff of the establishment concerned who have passed the SSLC or equivalent examination and have rendered at least 7 years of continuous service on the first day of the year in which the selection is made. The head of offices are advised to take action on the following line for preparation of the panel of names for such promotion. Now, Lordship will see, my lord, entire issue herein is regarding the education qualification, which has subsequently been amended in 2015, this 1967 rules to graduation. But my lord, so far as this particular circular is concerned, subsequently, my lord, no such circular has been issued, holding that, my lord, from 15 onwards, when the main parent act,
What is his graduate? What is his education?
he is a graduate.
He's a graduate.
Yes. So far as the one, my lord, who have been promoted, they are not graduate. That is his case. Now, my lord, this issue cropped up in, my lord, before his honorable court. And there, my lord, initially,
Your rejection is not on the educational qualification.
no,
Rejection is on the ground that there is no vacancy.
no vacancy. Yes.
Now, he points out from some
Last page.
what is this? Some chart at
Last
51. That 13, 14, 15. These are posts which are which were filled up on promotion.
Yes.
13, 14, 15, my lord.
So 13 and 14 are arrayed as parties.
Yes,
15 has expired,
my lord.
and that post remained vacant on a day when his application was rejected.
Yes.
That is his case.
When, on the day when the rejection was, my lord, issued.
So therefore, he could have been.
Here, Lordship may kindly see, so far as serial number 14 is concerned,
Hmm.
the caste status,
Hmm.
scheduled caste. Petitioner is not a scheduled caste, first of all. So that 14 part, that seniority, junior, that will not come because, my lord, he is a scheduled caste, he has been on his, my lord, category, he has been promoted. What remains is, my lord, 13,
15.
15,
13 is senior to you.
13 is senior. So 13 and 14, as such, my lord, challenging their promotion.
When did you join as peon?
My lord, the petitioner joined on 25/2/2010.
Twenty-five.
2010.
25 to 2010. So how do you say you are senior to 13 and 14?
My lord, 14, Lordship will see no, 13, I am not saying that. 13, he is senior.
Then
In
even
respect of-
even 14 is senior to you by 3 days.
No, my lord, I joined in the month of February. He joined in the month of October.
But he is a scheduled caste category.
Maybe, my lord, we don't know whether they have applied promotional quota or not. And their educational qualification is HS, column 7.
Hmm. The only thing is whether 15 vacancy is a promoting vacancy or
That Lordship will see the speaking order again, my lord, you have stated so in the affidavit. It says, my lord, in the second para, it is found from the office record that the total cadre strength in the establishment in the post of junior assistant is 7. Of which 90% is to be filled up by direct recruitment, as per this OM, my lord. While 10% is to be filled up by promotion from grade 4 employees. 10% of the total strength in the cadre of junior assistant is 1.7.
how many posts are there?
17. Total cadre strength. Hence, maximum 2 numbers of posts may be filled up by promotion from grade 4 employees. Since 2 persons are already, 13 and 14 are already there. Occupied by 2 promotees, petitioner so and so cannot be considered for promotion at that point of time. 13 and 14 petitioner itself is saying.
Subsequently, also his case is not considered.
Subsequently, when such vacancies will come, we will have to maintain the ratio. 90 and 90% is at the and 10%. Only 10% can be filled up by promotion. 90% will be direct recruitment. So that's why, my lord, the argument was advanced that, my lord, this private respondents, they could not have been promoted for the very reason that, my lord, they did not have the graduation qualification. Since, my lord, in 2015, that 1967 rules It has been amended.
Yes.
Yes, Lordship, I'll reply to what my learned friend has said. Lordship will kindly turn to page 45 of the writ petition.
Yes.
So this is the order passed by this honorable court in the earlier round of litigation. And Lordship will kindly mark the date. This is very important. Order dated 30/8/2018 at page 46. And I will read the penultimate para in view of the consent. Lordship, has your Lordship down below, my lord. In view of the consent of the parties, the respondent number 2 is directed to examine the petitioner's representation dated 9/3/2018 and take a decision there on within a period of 2 months from the date of receipt of the certified copy of this order. The petitioner shall also submit a copy of the writ petition along with a certified copy of this order. In the event there are 10 vacant posts of LD assistant as on date, the respondent shall not fill up 1 vacant post of LD assistant till a decision is taken by the respondent number 2 on the representation, petitioner's representation dated so and so. So, my lord, on 30/8/2018, this honorable court directed to keep 1 post vacant till my representation was disposed of. And my representation has been disposed of on, my lord, at page 48. 17/3/2022, page 48. So from 30/8/2018 to 17/3/2022, the interim order 1 post directed to be kept vacant by this honorable court was operating. And Lordship will kindly see when this serial number 15 at page 51, last page of the writ petition. Serial number 15, when he was promoted to junior assistant, my lord, 1 at column 5, 1/10/2019. So during the currency of the interim order, they have exceeded the quota and appointed this person, my lord, though he has expired. So it does not lie in their mouth to contest.
Where have you stated that this 15 is also a part of the promoting quota?
No, these are all, my lord, promotional.
From where have you stated all that?
My lord, at paragraph 9, I have stated about this fact, my lord. Paragraph 9 starts at page 13. May I read the para 9, my lord?
Yes.
That the petitioner begs to state that the order dated 17/3/2022 issued by the respondent number 3 has been stated that total cadre strength in the establishment of respondent number 3 in the post of junior assistant is 17, of which 90% is to be filled up by way of direct recruitment, while 10% is to be filled up by way of promotion from grade 4 employees. 10% of total strength of cadre strength of junior assistant stands at 1.7. Hence, maximum 2 numbers of posts may be filled up by way of promotion from grade 4 employees. Since 2 posts are already occupied by 2 promotees, the petition of the petitioner cannot be considered for promotion at this moment. But in fact, instead of maximum 2 numbers of posts, the respondent number 3 has promoted 3 numbers of incumbents to the post of junior assistant, that is respondent number 4, respondent number 5, and Kamal Sharma, who died on 24/9/2021. And at present, the post is lying vacant in the office of the respondent number 3. Be that as it may, during the currency of order dated 30/8/2018, the authorities could not have promoted Kamal Sharma, who was promoted on 1/10/2019 as junior assistant, as 1 post was directed to be kept vacant till disposal of the petitioner's representative. So I have categorically stated it was a promotion mine. And Lordship, one more document I have to place. Lordship, we have filed an additional affidavit. Lordship, kindly turn to page 132, running page 132.
Yes.
So, Lordship will kindly see, issued by Government of Assam Finance Taxation Department. Subject, Lordship will kindly see, regarding request for direction of the applicability of rules of governing promotion of employees for grade 4 to grade 3, reference letter number so and so. With reference to letters on the cited above, I am directed to inform you that the principal rules of Assam Ministerial District Establishment Service Rules 1967 and its amendment till 1999 were issued by the Personnel Department. However, its subsequent amendments with effect from 2/3/2009 were issued by General Administration Department. Further, as per these rules, the post of junior assistant is filled up by way of promotion from those grade 4 employees who have passed degree examination in any discipline from a recognized university or any examination in any discipline or recognized examination declared equivalent thereto and have rendered at least 7 years of continuous service on the first day of the year in which selection is made, and the criteria of seniority laid down in Rule 11 of the Assam Ministerial District Establishment Service Rules 1967.
Now, Mr. Goi, what is the process for filling up of the vacant post? Have you undertaken?
My lord, that part, my lord, some decision is yet, it is awaited, but today morning I called up the, my lord, I called up the department. They have informed that, my lord, they have taken the views from the personnel department. Personnel department has said that it will be, the graduation will have to be taken up as a educational qualification. But to that effect, my lord, the taxation department has not issued any notification or letter stating that now it will be, my lord, graduation. That is awaited, my lord. If some time is given, I can place that. And in fact, my lord, this honorable court in a similar issue.
We want to know
Hello.
if this serial number 15 post which is vacant.
Yes, ma'am.
Have you filled it up or you're taking steps to fill it up?
Or so far as the 15 is concerned,
Ah.
that my lord, I will have to take specific instructions.
13, you have no claim.
13 senior.
If educational qualification is graduation, then I have a claim because he is HS. 13 and 14 are HS. Educational qualification.
But that has to be accepted or taken over by the rules.
Yes.
Yes. So this is the document on 8 December 2014. It is their own document, finance taxation.
Which document?
At page 132. That's now I have read my
132.
Page 132.
Edition
Last 4 lines.
This is in 24.
Yes, there is a clarification issue that graduation will be applicable.
This is in 24.
It has been issued in 24 because there was a litigation before this honorable court wherein this issue popped up. The honorable court left it to the department and department has subsequently issued this notification.
Now, so far as the promotions already effected at the time, there is no clear finding that was there any finding in the earlier litigation that graduation is?
Initially, there was a finding. They filed a review. Review was allowed and the honorable court left it open to the department.
So in that case, 13 and 14 and 15.
Yes.
So 13 apparently is senior to you.
Yes, seniority was his seniority.
Senior to you. 14 is shown to be an SC.
Yes, man, shown to be.
15
during the current
till the time the rejection order was passed.
Interim order was operating.
When was he appointed after rejection order?
No, before rejection
that.
order. During the currency of your lordship order.
But to claim 15, you will have to satisfy that it falls within 10% of the quota.
Yes.
Let us say this 15 is promoted. But does it satisfy the requirement of quota
Yes.
as the percentage?
No, lordship will kindly see when there is a lordship restraint order, they have overreached that order.
Very well. They whatever they have done, let us say, is contrary.
Yes.
Does it ipso facto give you a right to that post, claim that post? At best, it will be sent for direct recruitment.
No.
Your claim is promotion.
Yes, yes.
For promotion, there must be a clear vacancy.
Clear vacancy.
There must be satisfaction of the rules, criteria, eligibility. You satisfy all.
Yes.
Only thing that you were not selected was that there were no vacancies because the criteria was, the percentage was not there. It is your case that no, this is not the correct calculation, but as per the calculation, 3 posts are available for promotion. Then perhaps you can have a claim.
Yes.
But if it is 2 posts,
No, as per rule, it will be 1.7, so 2 posts. So there is no difficulty on that matter. But my lord, whether they are following it, they are not following it, my lord. And when this honorable court said,
If they have not followed, they have wrongly promoted somebody that benefit, how can it be granted to you by a writ court? You are entitled to what is available to you under the rules.
yes,
You have
my
to
lord.
show that this 15 post is available to you.
No, my lord, that's why my limbo argument was of two parts. First, my lord, educational qualification, because now it's apparently clear that graduation is required, and 13 and 14 doesn't have graduation. And in respect of 15, my lord, there was my lord, he was promoted during the currency of, unless and until they pass with their, my lord, isn't that a contemptuous act, my lord? So how do they correct their wrong? They have to correct their wrong, my lord. And I've been wrong by that.
No, your correction of their, see, keeping.
So
you
what?
have to first satisfy that this post number 15 falls in the category, in the criteria of 10% reservation, 10% promoting quota.
It has to be because
Either you have to build up a case to say that it is 14 and 15, not 13 and 14, 2 posts.
my lord.
Your case is it is 13 and 14. But 15,
Because 15 is no longer there, so I could not have made him party, my lord.
15, which was already there. The 15, it was a vacant post. But instead of considering you, they consider somebody else.
Yes, my lord, that is what I have pleaded in para 9.
But to claim a right, you have to show that this 15 is also included in the promoting quota.
Yeah.
That, my lord, records will reveal.
My lord, we have explained it, my lord. 17 posts, 10% is only 2 posts. 1.7 round up to 2.
No,
Either you say that no, the cater strength is more, not
Yeah.
70.
the rules, my lord, is clear. So, my lord, can
It
they?
will be- See, there can't be negative equality.
I understand, but what I am trying to impress upon your lordship is, one part of the rule they say will adhere to it, and the other part which prescribes the education qualification, they will say will not adhere to it. Can that be the, my lord, meaning? And what will, and the interim order passed by your lordship will become redundant then?
The interim order, if it is redundant, what was the interim order passed?
To keep one post vacant till, my lord, my representation was disposed of. In between, they promote one, my lord. So is it not contemptuous? And your lordship knows, unless they pass with the content. At page 46, it starts. The last paragraph.
No, interim order in this matter.
Yeah, same petitioner. I said, no, this is the third round of meeting.
In this proceedings or earlier proceedings?
Earlier proceeding. It's a continuous. Then contempt petition was filed. In contempt, my lord, they came up with a rejection order. Then we filed this. Send the rejection order. In the present.
You are at liberty to revive the contempt petition if you feel that the interim order was violated.
No, that was when the rejection order was passed. That
See,
was,
even if some stricture is passed against the department, you don't get a promotion unless you satisfy that this post is included in the promoting quota.
that is why, my lord, no, that is why I humbly pray. Since, my lord, it is a creation of the department, whether this post fell under the promotional quota or not, it will be revealed from the record. How could have
The
they?
records,
Yeah.
get the records.
Though they said,
Order comment, may I read page 46, my lord, that interim part. Lordship will kindly see, it says, my lord, what the honorable court order was, in the event there are 10 vacant posts of LD assistant as on date. My lord, 17 is the cadre strength.
Yes.
In the event there are 10 vacant posts of LD assistant as on date, the respondent shall not fill up one vacant post of LD assistant. Lordship will see the condition first. Well, there will have to be 10 vacant posts on the date when the order is passed. Well, out of 17, let the petitioner show that, my lord, place before the honorable court that on the day when this order was passed,
then
there were
department should have filed a review. Get it corrected.
Oh, in the event, Honorable Court has not said that he is already there. In the event, let him show that 10 posts was vacant, my lord. From the order, when this order was passed till the day that the speaking order is passed. Out of 17, 10 posts will remain vacant, my lord, will not fill up.
My lord, 1.7 is
We
the.
can only direct them that if this post is not filled up. Or we record this statement that this post is not.
That
filled
I
up.
will have to take a specific.
Then your case will be considered.
Yes, ma'am.
That's all we can do.
If it comes within the
Unless
10%
you-
quota.
Yes. Unless you establish your case that there are 3 vacancies available in the property code.
Yes, there will have to be established.
So far as graduation is concerned, it is because we were asked before any of the proceedings earlier. That what is the criteria, how do you satisfy, what is the criteria? That was never done.
No, my lord, Lordship will kindly appreciate the difficulty of the petitioner. He is a grateful employee. Whatever records I could lay head on, I place it before the honorable court. If there was no, my lord, if the promotional quota was not filled up,
You tell us how many, what is the cadre strength?
17, my lord.
17. And where is the quota?
That
prescribed?
rule 6, note 1.
Where is that page number?
At page, my lord, 32 of the writ petition, down below.
32.
Note, small Roman 1, down below, my lord. Okay, may I make one small submission for your kind consideration, my lord? It is an admitted position that the cadre strength is 17. And as per these rules, only 10% of that has to be filled up by a promotion. So 17, 10% comes to 1.7, that is 2 posts. So if 2 posts of promotional quota were not available, then how could the person at serial number 15 could have been promoted?
That's what we are trying to make you
So, my lord,
understand.
they have to proceed the record.
If this is an illegality committed,
Yes.
that same benefit can't be conferred on you.
No, provided it is an illegality, but provided if it is not an illegality, then
That is for you to find out. You're before the court. We did not invite you.
no, that's why, my lord, I have produced the documents, whatever.
Whatever is
No, no,
there is
that-
there. It is not for the court to go on a roving and fishing expedition to call for records and find out.
By learned
You
colleague is
are
flying from
you are an
police report.
counsel, you know what are the means to procure the records and information from department.
Right.
So use that. Why are you using the medium of the court to call for the records so that it is convenient for you to examine the records and then you build up your case? That we can't be a party to that. Can we?
No, that is
Should
not-
we?
No, my lord, that is.
Then all good things must come to an end someday. So I think
No, my lord. No, but let them have instruction whether it is 15, serial number 15 is vacant or not, my lord.
that's what I said. All good things must come to an end.
Yes, ma'am.
So let it come to an end with the writer that your case will be considered as and when they proceed for promotion.
Yes, of course, my lord.
They have to consider.
If he comes within the zone of consideration. Not in the, my lord, this serial number 15 vacant post. Can't say that, my lord, that it will be.
We
within-
don't know.
Yes, whenever
It
the
is for-
cassette drive is taken, my lord,
No,
of
no,
course.
no. Serial number 15, if it is promotee, then you will have to fill it up by way of promotion. If it is direct recruit, you will advertise and fill it up.
Yes.
Unless the department takes a view that we don't want to fill up that many number of posts.
That's again, yeah, for.
There are so many ifs and buts.
But my lord, before that, whether it is vacant or not, let me have the inspection.
Yes, my lord, let him have the inspection.
At least on that, my lord.
Heard council both parts. dispute, the issue urged before the court is claim were promoted by the petitioner to a vacant post of LD,
Yes, junior
LD.
assistant, junior
What division
assistant.
junior assistant,
Junior division assistant, junior assistant, it is junior assistant nowadays.
junior assistant in the
As per the rule.
department of
Huh? Finance is under the commissioner of taxes. Unit two.
Unit two.
like
Unit two.
the petitioner claims to be a grade 4
Unit C.
employee having the requisite qualification. And in terms of the rules adopted by the department, the posts of junior assistant that are to be filled up by promotion to the extent of 10%, 90% by direct. So it is not in dispute that the cadre strength is 17. Equal to the cadre of junior. Or you say the cadre strength of junior assistant is 17. As such, the posts available for promoting for promotion from grade 4 post is 1.7 and rounded off. Respondents number 4 and 5 have been promoted by the department to the post of junior assistant, and it took them the petitioner challenges on the grounds that they do not possess the requisite educational qualification, which is graduation, as per the rules. The further contention of the petitioner is that the person shown at serial number 15 of so and so case was also a promotee who subsequently expired in the year 2021. So, counsel for the petitioner therefore submits that this post is available to be filled up by promotion, or which the petitioner, in which the petitioner's candidature could have been considered relevant. However, the same is rejected by the appeal order. Mr. Gogoi, an additional lady appearing for the health department, finance department, the other end submit that the imputed order clearly reveals that the cadre strength is 70 and 10% being 1.7 rounded off 2, namely 2 posts are required to be filled up by promotion. And that having been done and currently held by respondent 4 and 5, case petitioners to further submits that respondent number 5 is shown to be a scheduled caste candidate, and therefore petitioner being a candidate in the unreserved category. You are unreserved.
Yes,
Unreserved category can have no claim over that particular profile. And as far as respondent 4 is concerned, he was appointed. He is senior to the petitioner in the feeder category of grade 4, as he was appointed at an earlier date. So submitted that criteria for selection, criteria for promotion is seniority come merit. However, with regard to the vacancy, resultant vacancy available due to the demise of the person shown to be, what is his name?
Kamal Sharma.
Kamal Sharma.
Kamal Sharma. Whose name appears that real number 15 of the bill. He done it immediately, submits that like to complete his instruction. Any submissions from the respondents?
My lord, what my learned friend submitted, that is, but so far as the this thing, the notification that the petitioner for the petitioner has been submitted, that includes the higher this thing, high school living certificate, that has been replaced by the degree, not for the higher secondary. The notification is very clear.
High school?
High school living certificate. Those who are HSLC passed, for them only this degree has been.
And high secondary will continue to be high secondary.
higher secondary, there is the very writ petition notification itself says. So it doesn't attract us.
Asking for the respondent number
Four.
four. Dispute the content of the council of the petitioner and submits that the notification for enhancement of qualification of graduation, enhancement of eligibility criteria, graduation is not applicable. The respondent. Four. You are for respondent four
I am for the rest.
and five.
Okay, in the office memorandum itself, there is a clause at page 62, Lord, clause 5. It provides if any court order is there in respect of filling up of any vacancy of grade 3 or if any case of appointment or compassionate term is pending, those matters should be taken into consideration before filling up of any post of grade 3 by promotion from grade 4 employee. So in my case, there was a direction from this court, Lordship. So
Counsel for respondent five submits that since there was already a direction from the court in a writ petition filed by the respondent five.
yes,
What is the number? Being WP 312. Yes,
WP,
the petitioner was considered.
this is the
Give us the number
WP 3616 of 2018.
filed by you.
Yes, Lord.
3616 of 2002.
18.
2018. Filed by the petitioner, its case was considered. Considering the issues involved, it would be opposite to permit the state council to complete its instructions that they can see respect of the person promoted also your assistant subsequently expired is still available. And what step the department is proposing to undertake for filling up same. Let this instructor please.
Next week or immediately after vacation, madam?
Immediately after vacation will be in August. That will be listed in the second week of August. They'll be listed by the registry.
It is Guwahati Unit C. These vacancies are there in Unit C. Others, 4 units.
Unit C under the Office of
Office of the Eastern Commissioner of Taxes, Unit C.
Assistant Commissioner of Taxes, Unit C.
Deeply obliged.
Hey, please, sir. As for their prayer, Malad, they are asked for pay scale, Malad. They are not entitled for the pay scale, Malad. But as per that OM, Malad, that is in page number 217, Malad, 8 hours of work that they are an allowance of 1/3 of the salary, Malad. I have made the query before the ministry, Malad, that whether they are entitled for this under this OM, Malad, and that honorable that the ministry had requested to take some time for otherwise I am ready to, but that on the pay scale, Malad. Argument, I am ready to submit my argument on pay scale, my lord, as per the writ petition, my lord.
What is the instructions of the ministry?
Ministry, my lord, they ask some time, my lord, to for give it because they are examining this OM, my lord.
Which OM?
OM is, my lord, page number 217, my lord.
Repeat this one.
No, we have to say additional liquidity conference.
217.
Page number 217, additional affidavit filed by the petitioner, my lord.
How much time do you require?
My lord, immediately after vacation, my lord.
Every 6 months.
Yes.
We have enclosed these long before, my lord. This is with them only. Even then, they want to take time. They can take time. Let it be. My lord, Lordship so desire next week, my lord. Because we have completed.
Next week is not possible.
We have completed our argument, my lord.
But next week is not possible. No, it is the.
This instruction, this
Get it by next week.
Next week is not possible, madam, from the ministry also.
only instruction is required. This is applicable in our case.
No,
but
but
not-
they are examining.
4th of August, 4th of August. 4th August. Get it by 4th August. No. For the request made by levels. For the time required. From the. I think the application. Let's say.
OM dated. 4th September 2019 and OM date 1980.
Same.
7 June 1988.
Of personal, RPG and pension come into India. Regarding the applicability, the same word, claims made by the commission. The matter be listed on 4th August.
Must.
It's a hearing day, my lord.
Hearing date.
5th August.
We prepared a written argument last time. I also mentioned we can hand it over to your lordship or.
You can mail it to the court master.
Well,
Must of this.
5th of August. Basically. Yes. Hey, instructions from the Goa. Lots of instructions were supposed to be.
Affidavit I have filed.
So, the order 9/6, we permitted you to complete the instruction.
Lordship, one OM has been annexed, Lordship, in the repetition, that is of 2009.
On
What-
that, instructions on that.
On that point, Lordship, but I had gone through the affidavit, Lordship, that point has already been covered in the affidavit.
Right, where is that affidavit?
Lordship, the affidavit was filed on 9/5/2024 in my record. Lordship, in this case, what happened, Lordship? This is the first case of its kind, Lordship, I am seeing, Lordship. In fact, Lordship, all those persons who have been regularized in the year 2025, Lordship, initially a decision was taken to give them the benefit of new pension scheme. But subsequently, Lordship, by issuing that notification of 2009, it was decided that no, this will be covered by the old pension scheme and not new pension scheme. Accordingly, all the persons who have retired in the meantime, they have got the benefit under old pension scheme. But in this case, Lordship, if Lordship comes to paragraph 4 of this affidavit. That the answering deponent begs to state that the GPF account opening proposal was sent to AG Assam along with other 27 numbers of employees by TO letter number so and so dated 4/2/2006. That is immediately after regularization. 5. The answering deponent begs to state that the Accountant General Assam returned 11 numbers of application proposal out of total 28 numbers, including the GPF opening proposal of the petitioner, Sri Purna Gogoi, stating in the body of the proposal that the age of the applicant below 18 years at the time of joining of the service. That may be an issue, Lord. In paragraph 6, the answering deponent begs to state that the state government of Assam has introduced a new defined contributory pension scheme for employees joining in service on or after 1/2/2005 by notification number so and so 18/10/2012. 8, Lordship. 7. Answering deponent begs to state that the treasury officer also refused to accept pay bill in respect of employees who have neither GPF account nor NPS number. 8. The answering deponent begs to state that the petitioner, Sri Purna Gogoi, applied for allotment of MPS number on pre-11/2011 with duly signed in the declaration forms of terms and conditions of new defined contribution pension scheme. Accordingly, competent authority allotted the PRAN bearing number so and so to Sri Purna Gogoi, and contribution to NPS is in respect of Sri Purna Gogoi started from January 2012. So he used the option to get registered under the new pension scheme. And if Lordship comes to paragraph 9, the answering deponent begs to state that the petitioner, Sri Purna Gogoi, retired from government service on 30/11/2022, and the pensionary benefits due to him as per norms of NPS were prepared with earnest at this end and received by the retired government servant, which are as follows: leave encashment of unutilized earned leave service, GIS saving fund, exit and withdrawal of NPS deposit. Now the monthly NPS pension has been drawing with effect from 1/12/2022. So he is drawing pension, but in terms of NPS. That is the case, not effectively.
What is that office memorandum that referring to?
2009 note. Office memorandum, which one?
This 2009.
Yeah, it is in the case 28, Lordship, in the repetition. Lordship, it reads is consequent upon issue of circular number 25/1/2005 on applicability of new contributory pension scheme in respect of government servants joining the state government service on or after 1/2005, a question has arisen about workforce employees and master roll employees who entered government service prior to 1/2005, but whose regularization were done after 1/2005. A substantial portion of their workforce and master roll service have already been decided to be counted towards qualifying service for pension gratuity. It is clarified that such workforce and master roll employees shall not be governed by the new pension scheme, but may be treated as per existing Assam Service Pension Rules 1969. Similar such cases, if any, may be entertained after obtaining the.
So they want the benefit of this. You want the benefit of this certificate.
Yes, but it was not denied. It was in 2009. Lordship, rightly or wrongly, it was rejected by the Accountant General. Thereafter, Lordship, he opted for the new pension scheme. And it was allotted in the year 2012.
Where was it rejected? Where was it rejected?
Lordship, may kindly see the rejection order at Annexure 1, Lordship, of the affidavit, Lordship. Page 38. We are now taking
Page
38, Lordship, Annexure 1.
38.
It is 27/3/2006.
Yeah.
Office of the Accountant General. Consequent on receipt of GPF statement application for allotment of GPF account number, I am to inform you that following GPF account numbers have been allotted in respect of the employees working under your control. This may be intimated to concerned authority at your end with following instruction. The account number allotted against rejection.
This is not the rejection.
Lordship, it comes to page 40.
very legible, page 40.
Yes, this is.
What is there in the remarks and all that is not legible. Do you have a legible copy?
I have to obtain one loss. I have to obtain one legible copy.
40. Do you have any legible copies with you?
News with us only. আমার লগতে
You
আছে।
furnish a legible copy.
Lordship.
Furnish it.
Lordship.
Where is how much time you? So how this affidavit was allowed, I don't know. It should have been detected at the fighting.
Yes, Lordship.
Tell us when can you get it?
In 1 week's time, I'll obtain it. Lordship. It will come from the Jorhat Lordship. Jorhat.
July? You'll have it in July?
Yeah. And date is
The rejection of the petitioner's claim.
That's the open for late. Can you election not like?
Rejection of the petitioner's claim by the accountant general. Is opposed to the affidavit filed by the respondent number 2.
Election order by.
Stop. The said document is available at page 40. Page 40 of the state is marked at page 40, marked
Yeah.
as page 40 in the state affidavit. The same is not legible. The respondent will obtain required instructions. Produce a more legible copy on the next date fixed. Placed in the month of July 23rd July.
Lordship. On 25th, that's all. 25th.
Not 23rd. Then on
29.
28th of July.
Lordship.
28.
Public.
But I'm praying for an adjournment in this matter for the day, my lord. A senior to leave the court premises now.
Item 17. Then adjourned to be listed after 2 weeks.
Lordship, on last location, Lordship directed to produce certain instruction, Lordship, which we have obtained, Lordship.
Keep it with you. Let the matter
Lordship.
hold up again. When it's hold up. Yes, after 2 weeks.
Deeply obliged, Lordship.
My pleasure, Lordship. I was appointed by NHM and posted at Tigarkusi Subcenter under Boroma BPHC. During my service period, I was absent for 3 days, 8/12/2024 to 10/12/2024. Due to excessive bleeding from uterus, I was unable to attain my duty. Thereafter, the respondent authority issued show cause notice. Show cause notice, page number 21. Thereafter, I had submitted a reply, page number 22.
Yes.
Page number 22 and medical prescription, page number 24. Page number 24.
Yes.
Clearly written that excessive uterine bleeding 7 days, 7 days.
Yes, then what happens?
Rest. Thereafter, the respondent authority issued the impugned order, page number 26. Joint Director of Health Services, Baksa. Thereafter, I approached before this honorable court, and the respondent authority has filed affidavit, and thereafter, I have filed a reply in my page number 69. Page number 69, running page number. This order has been passed by Director of Health Services, whereby all attachment order of grade 3 and grade 4 employees are cancelled and directed to release the grade 3 and grade 4 post. Those are transferred with attachment. Thereafter, even the respondent authority has filed an affidavit, page number 72, relevant paragraph. Page number 72, para, third para.
Yes.
It is pertinent to mention herein that as petitioner is an employee of National Health Mission administered by Government of Assam only, the NHM has not been handed over public transfer to BTC administration as on date. The Mission Director Health Mission of Gov of Assam is the competent authority, hence BTC has no role in this regard.
Now, so you are agreed by which order? Page 26.
Page number 26.
So that order has been recalled, not recalled.
Not recalled till date.
No, but you have pointed out some release order. Some subsequent order passed.
Thereafter, no order has been passed. A release order, page number 27. Thereafter, I approached before this honorable court.
Now, this page number 67, what is this order?
67. This order has been passed by Honorable Chief Minister.
67.
67. Yes. This order has been passed by General Administrative Department. As per this order, the page number R 69 has been passed by Director in view of this 67.
Yes, respondent.
Lordship, I am for BTC Lordship, Health Department also party Lordship. Our main reason for transfer is public interest Lordship. I have stated in paragraph, page 71.
No,
to
that's
70
all right, but what do you say about page 67?
67. 67 is issued by the Commissioner and Secretary, General Administration Department, Lordship. It is stated that all attachment, service of grade 3 and grade 4 employees coming under.
Why this order has not been complied with?
Lordship.
This is for reverting back to reverting all the persons on
That's
attached
why, that's
to
why
the
I'm,
parent department.
that's why I'm saying, Lordship, that where she is attached, that sub-center is approximately 6,780 population. There is no ANM, Lordship. And where she was earlier doing the service, there are only 16,000 and another ANM also there, Lordship.
No, but then again, you pass some order saying that it is not a transferred subject.
Yes, do not transfer subject,
Huh.
but executive committee has decided for the crisis of ANM
That
Lordship.
you can't do if it is not a part of your subject. Then how can you pass an order? You may submit a proposal.
Yes.
Hmm?
It's true, Lordship, but
Then?
due to
How can it be? How can somebody overreach and say that we will pass an order? Then you stand by the statements made at page 72.
yes.
PTC has no rule.
Yes.
Is he the same person who passed the order at 26?
Okay, the
Lordship, this is a different. He transferred and thereafter.
No, same office.
Same office, same joint director.
So order should have been recalled immediately.
Yes.
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 Third, counsel for the party. The petitioner is serving as an ANM nurse under the National Health Mission and under the administrative control of the District Health Society of the District of Bausa. Stop. She was appointed by the order dated 4/3/2017 and she joined on 10/3/2017 in Singimari Sub-Center, Bongaigaon, under the Office of the Joint Director of Health Services, Member Secretary, District Health Society. Stop. The case projected before the court by the that the petitioner suffered from some medical ailment, suffered from some health issues, because of which she was on leave for how many days? 5 days?
3 days.
3 days.
Only 3 days.
3 days. In support of the contention, the counsel for the petitioner is referred to the medical documents enclosed to the writ petition to show that the petitioner was advised bed rest for 5 days by the medical doctor for the condition that she had suffered. So the same was also informed to the Office of the Joint Director Health Service. Stop. The petitioner was served the show cause on 11/12/2024 and she replied to the show cause
এইটো order পাহৰি গৈছিলো গোটেই কিবা এটা instruction আমি কৈছিলে বা নাকি
You replied to the show cause.
Yes, Lordship. Page number, Lordship, page number 22.
He replied to the show cause, explaining the reason why she could not attend her duty for 3 days. So, however, without considering the grounds and reasons it's for her absence from service, petitioner was served with an order dated 19/12/2024. By the said order, he was attached as a A&M at the Brangpar Sub-Center under NIS Kaurabha, BPHC, Tamilpur district, with immediate effect. Page number 26. So, pursuant to the said order passed, the petitioner was released from Haikarkuchi HWC under Boroma BPHC, Boxa, enabling her to proceed for and join in the new place of posting. So, the petitioner filed an application represented before the authorities concerned. However, the same has not been considered. Stop. That apart, the local residents of Haikarkuchi Health and Wellness Center, also represented before the Joint Director, Health Services, ONSA,
এইটো যে এটা instruction আমি কৈছিলা
requesting for recall of the order of attachment as she is stated to be rendering good service to the local residents. So, since the petitioners please, please were not taken into consideration by the respondent authority, which is approached this court by filing the respondent number 3 has filed an affidavit contesting the claims of the petitioner. Subsequently, an additional affidavit has also been filed by the same office of the Joint Director. In Joint Director Musalpur Boxa. So in the said affidavit, there is a clear averment at paragraph 3 that the petitioner is an employee of the National Health Mission administered by the government of Assam only. Stop. The NHM has not been handed over / transferred to the PTC administration as on date. Stop. The Managing Director, National Health Mission,
Lordship,
Government of Assam.
Lordship, not managing director. It should be mission director.
Mission Director of National Health Mission, Assam, is the competent authority,
managing director
and the PTC authorities have no role in this regard. Apparently. Learned Standing Council for the PTC submits that does not Learned Standing Council PTC also submits that this is the position as the NHM has not been, is not a transferred subject to the PTC. So under such circumstances, this court is of the view that where the affidavit is filed by the office of the Joint Director, Paksa, to the effect that the mission director, NHM, is the competent authority. And as the NHM is not a transferred subject. Kumar. And where there is no dispute that the petitioner is employed as an ANM under the National Health Mission. And no further explanation has been offered as to how the impugned order of transfer attachment would have been passed by the Joint Director in view of the averments made in para 3 of the affidavit in opposition filed on 25th of April 2025. This court has of the view that the impugned order is clearly an order passed by an authority not competent to do so. Stop. The averments made in the affidavit have not been sought to be withdrawn. And in view of such clear averments made in the affidavit, this court is of the view. Yes.
One thing, whether the page 67 also will see that there was a notification or it's a letter or communication issued to all the secretaries that whoever is working on attachment is to be reverted back. Yeah. And it has been issued as per direction of the highest authority.
The impugned order therefore needs to be set aside, and the same is hereby set aside. Stop. It is ordered according. Here, reported a line double. It is also to be a communication, a communication dated 19/1/2025 issued by the Commissioner and Secretary, General Administration Department, which is issued to all commissioners or all the senior most secretaries of all departments. Stop the same communication clearly conveys the decision of the government at the highest level that all employees in grade 3 and grade 4 who are presently working as within quotes attached in various district or subdivisional offices are required to be released for enabling them to return back to their parent postings. So this the amendments made in para 3 of the affidavit appears to have been made pursuant to the such notifications issued by the General Administration Department. The impugned order dated interfered and say.
So far as the Joint Director is concerned, he is a competent authority.
He is making a statement that the NHM is not transferred. That's what we are saying, asking her.
No, in fact, my lord, with page 26. For a moment, my lord, also will say page 26.
No, I don't know if you have a copy of the affidavit, you have a look.
এটা কাজটা নরমালি করছে নিজে এখানে কি রিফ্রেশ হয়ে গেল
No, so far as the affidavit is concerned, it has only stated about the authority. That it is not a transfer subject. But so far as the NSM is concerned, various schemes are to be implemented through the Joint Director.
It's a different issue.
Yes, man.
The affidavit has been filed.
Misconceived, totally misconceived. What I'm saying is, he's the secretary of the
affidavit on no. They withdraw it or you give a further explanation, we'll have to go by it.
But then, may I have the
directions, the observations of this court
respondent to I will file an affidavit.
Are on the facts and circumstances of this case, and more particularly in view of the statement made in the affidavit. That's all.
Where is NSM gonna like it?
Allowed.
Well,
Dispose.
we said the-
When the PTC wants to say, why are you putting words into their
My
mouth?
lord,
Obliged.
well, in this case, my lord, on 16/6, they filed one additional affidavit. We'd like to respond to that. 17/6.
Yes, Mr. Kakoti.
They have a right to file a reply. But on the fixed, date may be fixed, Lord. I'd be wishing if the lordship fixes that next week itself. But that is
Next
not
week.
possible then immediately after the vacation.
Next week, we don't know. What is the matter about?
It's about disciplinary proceedings, lordship.
Immediately after vacation, my lord, on 24th, my lord.
No, no,
July.
24, there are too many matters. Has to,
July.
we will have it in the first week of, second week of August. First week of August.
August, let it be in July probably, or if possible.
July, we have already fixed lot of matters. So this will require some hearing. It's a disciplinary proceeding.
Lordship.
We'll have it in August, on 5th or 7th or whatever date is.
I would like to please. 70 by.
Heard. Parties,
Seven, my lord.
Mr. Koi,
Hearing
counsel for the
Second
petitioner
Thursday.
submits
7.
that they would like to file a rejoinder affidavit to the affidavit in opposition filed by the respondents. Para Mr. R.P. Kakoti, counsel assisted by Mr.
As to the lordship.
S. Sutrodhar appears for the respondent. As agreed to by both parties, matter be listed on 7th of August
There is the interim that may continue.
for admission. Interim order passed earlier will be
It is an additional affidavit. We will be countering to that, not agreement.
additional affidavit, rejoinder to the additional affidavit filed by the respondents. Yeah.
Obliged.
Yes,
Lordship had heard it on some extent to that raiding entry case, Lordship.
yes.
May it please your lordship, my lord, may I pray one thing, my lord, I am falsely implicated, my lord. Records may be produced because they have taken it personally, my lord. I have entered the expenses. I have taken the luggage of the major from Delhi Army Canteen to Nagaland. When I approached the expenses, they falsely implicated, you are intoxicated. Secondly, firstly, my lord, my daughter was it.
Those things you have not challenged it.
My lord,
You have to challenge those
after
these entries
yes,
where you have already been punished, etc. You have not challenged them.
my lord, I have every time, my lord, I have given reply to the SOCOs, my lord, they have not listened to me.
Which report?
My lord, last SOCOs, my lord, they have given kindly see in their affidavit in opposition, my lord. They have given me SOCOs, my lord, setting my all the offenses, my lord. And for that offense, my lord, SOCOs pay Annexure D, page 73, my lord. Page 73 of the affidavit in opposition, my lord. Before discharge, my lord, they have given me this SOCO notice. May I read, my lord?
No, these, it reflects some punishments already imposed.
Yes, my lord.
Have you challenged those?
My lord, in every punishment they have given me, my lord, my lord, rigorous imprisonment, pay fine. But what, my lord, discharge is necessary, my lord? Because my lord will see the rule, my lord. My lord will see the rule, my lord. First, my lord, absenting himself without leave. This is Assam Rifle Act 2006, section 26A. And my lord, 26A, my lord, what does say, my lord? May I read, my lord?
Why are you now trying to reopen these punishments? These have already been punished. You have undergone the punishment.
Then, my lord, can we see
The
reply to
question is whether this entitles you to any red ink or black ink entries.
my lord, then kindly see reply to my SOCOs. Annexure C, page 75 of the affidavit in opposition. Reply to the so-called notice dated so respected sir, I understand most respectfully beg to state that a so-called notice dated 25th May 2024 was served upon me on 25th of May from the office of the Commandant 41 Assam Rifle, whereby I am directed to submit my reply on the so-called notice within 15 days from the date of receipt of the so-called. I would like to submit as follows, my lord. I am a citizen of India by birth and as such I am entitled to all the rights protection. My lord, this is formal. Then I was enrolled in Assam Rifle on 20 December 2008 as a rifleman. After completion of military training, I was posted 41 Assam Rifle in the year 2009. Since then, I am serving the nation with all sincerity and dedication. In view of the excellent service conduct, I was posted at various places in Northeast region. There in the month of April 2019, that is almost, my lord, almost 10 years of my service, my lord. I was posted to Zubra Post 41 Assam Rifle. I received a call from my home that my daughter was seriously ill and admitted hospital. Thereafter,
Why are you reopening these issues?
my lord, reply to the so cause, my
What
lord.
reply to the show cause? You are replying to all these proceedings on which you have punishment has been served.
Yes, my
It
lord.
is your call to reply or not to reply. But prima facie, this reply is meant for this warning letter, isn't it? So warning letter has given you all these instances.
My lord, I have said that in this reply, my lord, as I have served the department almost 17 years of service, let me complete my pensionable period. In this reply, my lord, I have said like this, my lord. And for that, my lord, my lord, kindly say last para, says para 10. I beg to state that I am the only breadwinner in the family. I am a married.
You are making a
Then, my lord,
mercy, forget
yes.
about a mercy petition. You show us about the rules
My
and
lord, as
procedures.
per that all for the reply to the so-called, because they said you submit
Your
the
reply is nothing but a mercy. You reply showing that any action sought to be taken under the provisions is not warranted.
My lord, I am
Where is that reply?
reply my lord, last para, my lord, I am reading.
Hmm.
Others I further request to set aside the charges made against me because here I have said that all allegations are false and allow me to
No, these
complete
allegations cannot be false
my
now.
20 years of service up to the December 2028. I am governed by CCS pension rule 1972, now 2021. 20 years of service is compulsory.
How
for
many years have
PhD.
you put in?
I have 17 years. My lord, if I complete 20 years of service, my lord, I will get pension. They have to see, my lord, all these things also because for last 1 year, I am, my lord, peacefully I am doing, my lord. Because of, and there are person in Assam people who have got 9 rating and they may discharge me, my lord, but they have to see all the conditions, my lord.
What are the conditions?
Conditions, my lord.
What are the parameters set forth to discharge you in
My lord,
rating?
first I go to their regulation, my lord.
Yes.
Regulation, my lord.
Sub-rifles regulation.
Regulation I annexed, my lord, but one page missing, that's the new copy, my lord. Assam Rifle regulation, my lord.
This is
Kindly,
expect of the regulation.
my lord,
Regulation देखो यहाँ. Regulation देखिए.
Assam Rifle regulation 2016. Regulation. Lord, 107 is
All right, 107.
107 and 108 both. 107, my lord, removal of undesirable, incorrigible, insufficient subordinate officer. They have said me incorrigible offender.
Where is that order of removal?
WBC, my lord, kindly see. Page 29. Page 29. Annexure 3, my lord.
Yeah.
It is considered that the conduct number so and so, which has led him incur 4 rating entries, is such as to render his further retention in force service undesirable, being an incorrigible offender, and having shown no improvement in his service. And so was afforded an opportunity to show cause against the proposed action by sector quarter number so and so. He has submitted his reply by the application. Just now I have read, my lord. Submitted reply on 3rd June 2024. Same was considered in terms of para 108 of Assam Rifle regulation and was found unsatisfactory. Then, my lord, in exercise of power conferred on me under provision of 11(1)(2) of Assam Rifle Act 2006, my lord. So from the Assam Rifle being incorrigible offender with effect from 11th of August 2024. My lord, this order was passed, my lord, on 5th. I came on 7th, my lord. 9th notice was issued, my lord, because of status quo. My lord, I am continuing. Last 1 year, my lord, I am continuing just like a normal, my lord, without any difficulty, without any, my lord, problem, and with my full salary, my lord. Then, my lord, can you see this? They have not stated here, my lord, why my reply to the so-called is not satisfactory. No reason is given here, my
It is
lord.
apparent. Your reply to the show cause is not satisfactory. The prima facie we can see that. You are referring to the earlier punishments already done
No,
and dusted. You have to now explain as to why rating the discharge in the face of 4 rating entry is not possible. That's the question.
Then, my lord, kindly see 107, my lord. Removal of undesirable, incorrigible, insufficient subordinate officer, under officer, and under enrolled person. A subordinate officer, under officer, and under enrolled person who by his conduct has proved himself undesirable, incorrigible, insufficient, whose retention in service is therefore considered unsuitable for the force, will be recommended for discharge, dismissal from service. Dismissal should only be recommended when an Assam Rifle Court, if held, would have awarded a sentence not less than dismissal, but trial by Assam Rifle Court is considered impracticable or inexpedient. In other cases, recommendation will be for discharge from service. Before recommending or sanctioning discharge, the following points must be considered. If lack of training is cause of, this is not in my case, if an individual has become unsuitable through no fault of his own, he will be recommended for suitable extras. The procedure for dismissal discharge of unsuitable subordinate officer will be as under. As provided under Rule 24 and 25 of Assam Rifle Rule, the person concerned, subject to exception mentioned above, shall be served with a show cause notice against the contemplated action.
Then when you're reading 107, the rule regulation relevant for you is 108.
No, both, my lord.
How both?
Because here, my lord, kindly see.
Discharge on being rating entry.
No, my lord, incorrigible offender, my lord. In the discharge order just now I have shown, my lord.
Incorrigible.
Yes, my lord.
Right. So what does 108 say?
108 only rating entry, but incorrigible 107. And my lord, in my lord Amoyendra Kumar Pandey's husband, my lord, which I have annexed in annexure 1 of my affidavit in reply, this 107 is also, my lord, quoted. I will show, my lord.
First you take us to the regulation,
Yes.
108.
Then, my lord, preliminary inquiry. 107 is also necessary because I am an incorrigible offender, my lord, for that. Before recommending discharge or dismissal of an individual, the authority concerned will ensure that an impartial inquiry, not necessarily a court of inquiry, has been made into the allegation against him and he has adequate opportunity of hearing. Here, my lord, impartial inquiry is necessary. In my case, no inquiry was held, my lord. Rule 24 of Assam Rifle Rule confers powers on the commanders of the Assam Rifle establishment to discharge any subordinate officer under so and so. However, the power, this is my lord, power, my lord. After compliance of the provision enumerated, a so cause notice, this is also given, my lord. Then, my lord, headquarter for approval of superior authority sector commander. This is done, my lord. Then, my lord, kindly come 108. Discharge on the ground of rating entries. Subordinate officer, under officer, or other enrolled person who has incurred poor rating entry may be recommended for discharge from service on the ground of unsuitability. After an individual has earned 3 rating entry, he shall be warned in writing. His service will be liable to be terminated by the competent authority if he earns 1 more rating entry. Then, my lord, is case of individual having earned 4 rating entries shall be examined on his own merit, depending upon the nature and gravity of the offences and the aggravated circumstances under which these were committed. The authority competent to sanction discharge under this para shall record the reason for ordering his discharge or otherwise. Here, my lord, every, my lord, situation is to be examined, my lord. A person who has put in 18 years of qualifying service for pension may be allowed to complete the required qualifying service for grant of pension. Then, my lord, before taking the final decision to order the discharge, the person concerned shall be informed through a so cause notice that his retention in service is considered undesirable for having incurred 4 rating entries, thereby also calling upon him to show cause to why he should not be discharged from service, being considered unsuitable for the service. The individual shall given minimum 15 days time after receipt of so cause notice. After receipt of individual reply, if any, the case shall be put up to the authority competent to sanction the discharge along with recommendation of the commandant of unit concerned. Before passing the discharge order, the authority competent to sanction the discharge order under this para may seek advice of the law officer concerned. But, my lord, to my information, this was not done, my lord. An office order of discharge, this para shall be passed by an officer not less than a sector commander in case of under officer or enrolled person, and the officer not less than Inspector General, Director General in case of subordinate officer. My sector commander, my lord. So, according to, my lord, this regulation, inquiry is necessary. And then, my lord, every, my lord, situation is to be examined on its own merit. Then, my lord, they have to seek advice from the law officer. In my case, my lord, this was not followed. This regulation I have next knowledge in my petition. And, my lord, one advisory also I have, my lord, annexed in my writ petition. My lord, can we see them, my lord? Annexure 6 of page 38 of my writ petition. This is passed by them in 15 July 2021. Advisory discharge from service for incurring 4 rating entries. The advisory on the subject is issued in the light of the judgment passed by the Honorable Supreme Court of India for handling discharge of service personnel on incurring 4 rating entries as per existing provision of Assam Rifle Act 2006, Assam Rifle Rule 2010, Assam Rifle Regulation 2016. They have to follow the Assam Rifle Rule 2010 also, my lord. Then, my lord, they have given on the basis of Birendra Kumar judgment, height para 10 of the judgment, before discharging an individual, not only should there be a so cause notice, but an inquiry into the allegation made against the individual concerned, in which he ought to be given an opportunity of putting his defense, and the allegation must stand substantiated for a discharge to follow. Then, by para 13 of the judgment, there is nothing on record to suggest that competent authority had taken into consideration the long service rendered by the applicant, the difficult condition, the harsh station in which he has served. There is nothing on record to suggest the nature of the duties is not legible, one line, my lord. Then next, my lord, in the result, appeal succeed and hereby allowed. The order of discharge passed, again the appellant is hereby set aside. Since the appellant has already crossed the age of superannuation, interest of justice will be sufficiently served if we direct the appellant shall be treated to have been in service till the time he would completed the qualifying service of pension, my lord. Keeping in view of the judgment of the Honorable Supreme Court, the competent authority has issued the following guidelines, my lord. The case of the individual on incurring 4 rating antics should be examined for its own merit, depending upon the nature and gravity of the offense and the aggravating circumstances under which the offenses were committed by the individual. Then, my lord, discharge from the service incurred 4 rating anti is not a mechanical process. The termination of service is warranted on the merits of a particular case and in each case to be examined in detail based on facts and circumstances. The total service rendered by an individual should be considered, and wherever possible, individuals should be given an opportunity to complete the qualifying service for grant of pension. Before discharge an individual from service for incurring 4 rating entries, adequate opportunity should be provided to the individual for his defense by way of convening an appropriate inquiry. It is reiterated that in order to uphold the discharge and end of the force, it becomes pertinent to set an example while disposing of such offences. However, also assume importance to provide adequate opportunity to the delinquent person to defend his case in the eyes of law for the interest of justice. My lord, they have passed their own advisory, they have passed their own regulation, and it is not automatic that I have earned 4 rating. Before 4 rating, my lord, the offences which I have committed, my lord, for that I have been punished, my lord. I have been given rigorous imprisonment, I have been given pay, fine, everything I have gone, my lord. In spite of that also, my lord, as soon as, my lord, I have been given 4, my lord, they order discharge order. And my lord, in Assam Rifle, there are 9 rating persons are also working. It is their discretion, my lord, that I admit, my lord. But taking my length of service and nature of gravity of offense, they should have, my lord, given me up to the age of 20 years so that I can get pension. Because in my reply to the so-called, my lord, I have clearly stated that all are false allegations. However, I admit it, but because of my length of service, I may be allowed to continue till the completion of 20 years. Then, my lord, kindly come, my lord, my affidavit in reply. Here, my lord, mainly I have annexed the Honorable Supreme Court judgments, my lord. One is, my lord, Annexer 1, page 123, Amarendra Kumar Pandey, my lord, versus Union of India. This is, may I read, my lord, whole judgment or relevant? Annexer 1, page 123. Name of the Amarendra Kumar Pandey. Affidavit in reply.
You read it.
Affidavit in reply of my lord, Annexer 1.
You read.
Amarendra Kumar Pandey, appellant, Union of India and others, respondent. Very long judgment. The analysis, may I read, my lord? 137, my lord, page. Having heard the learned counsel appealing for the parties and having gone through the material on record, the only question that calls for our consideration is that whether division bench of the High Court committed by error in passing the impugn order. We must first look into the decision of the court rendered in case of Virendra Kumar Dubey, Supra. In the said case, appellant Virendra Kumar Dubey was enrolled an operator in the corps of Artillery of Indian Army on 27/9/1980. Having served in that capacity for nearly 12 years, he received a so-called notice pointing out that he had been awarded poor rating entry for various offences set out in the notice, and that Virendra Kumar Dubey had become a habitual offender, thereby setting a bad example of the indiscipline in the army. Virendra Kumar Dubey ultimately came to discharge from service by an order dated 14/12/1992. He preferred a departmental appeal which failed. He therefore went to the High Court of Madhya Pradesh at Jabalpur. However, the High Court declined the entertainment on the ground of lack of jurisdiction. He therefore preferred an appeal before appeal court, and writ appeal was ultimately ordered to be transferred to the Armed Force Tribunal, Regional Bench, Lucknow. The tribunal ultimately dismissed the transferred petition, which gave rise to the appeal before this court. This court in Virendra Kumar Dubey held that it is common ground that a rating entry may be earned by an individual for overstaying leave for 1 week or for 6 weeks, 6 months. In either case, the entry is a rating entry and what would qualify for consideration in the matter of discharge. If two persons who suffer such entries are treated similarly, notwithstanding the gravity of offense being different, it would be unfair and unjust for unequals cannot be treated equals. More importantly, a person who has suffered for such entries on a graver misconduct may escape discharge, which another individual who has earned such entries for relatively lesser offences may be asked to go home prematurely. The unfairness in any such situation make it necessary to bring in safeguards to prevent miscarriage of justice. That is precisely what procedural safeguards purported to do in the present case. Taking the aforesaid view, court ultimately passed the following order. In the result, appeal succeed and hereby allowed. The order of discharge passed against the appellant is hereby set aside. Since the appellant has already crossed the age of superannuation, instead of justice will be interest of justice will be sufficiently served if we direct that appellant shall be treated to have been in service till the time he would have completed the qualifying service for grant of pension. No back wages shall, however, be admissible. Benefit of continuing service for all other purposes shall be granted to the appellant, including pension. Monetary benefit payable to the appellant shall be released expeditiously but not later than 4 months from the date of this order. Then, my lord, para 24. In Vijay Shankar Mishra, the appellant thereon was enrolled in Army Medical Corps on 23 June 84. On 3/1/97, a notice to Sokos was issued to him to explain why he should not be discharged from service under Rule so-and-so Army Act on the ground that his conduct and service had not been found satisfactory. He ultimately came to be discharged from service. By that time, he had rendered service of 13 years and 8 months. The minimum qualifying service for earning pension under 130 Rule pension for Army is 15 years. He filed a writ petition before the Madhya Pradesh High Court, which was dismissed on remand. In appeal, a division bench directed reconsideration of the case of the appellant. Pursuant to order of High Court, an order was issued rejecting his claim for pension on the ground that he had not put in 15 years of service and he had been discharged for service that he was unlikely to become an efficient soldier. He filed again a writ petition before this Madhya Pradesh High Court, which was transferred to Armed Force Tribunal. The tribunal dismissed the matter. Thereafter, Mishra came before this court. The very same argument was canvassed before this court on behalf of Vijay Shankar Mishra that mere fact that he had been punished while in service on 9 occasions, inclusive of 6 rating entries, were no ground to exercise the power under relevant rule for the purpose of discharge. The court relied upon the Vijay Shankar Mishra as under. In the present case, it is evident that there was no application of mind by the authorities to circumstances which have to be taken into consideration while exercising the power under Rule 13. The mere fact that appellant has crossed the threshold of 4 rating entry could not be a ground to discharge him without considering other relevant circumstances including the nature of violation which led to award to the rating countries, whether the appellant had been exposed to duty in harsh session and to difficult living conditions, long years of service, just short of completing the qualifying period of pension. Even after Madhya Pradesh High Court specifically directed consideration of his case, bearing in mind the provisions of the circular, the relevant factors were not borne in mind. The order that was passed on 26 to 2007 failed to consider relevant and garment circumstances and does not indicate a due application of mind to the requirements of the letter of Army Headquarters dated so and so and circular dated so and so. For the reasons, we are of the view that Armed Force Tribunal was in error in rejecting the application. The order of tribunal dated so and so are set aside. Since the appellant would have attained the age of superannuation, the ends of justice would be met if it is stated to have been in service till the time he would have completed the qualifying service for grant of pension. No vacations shall have, however, be admissible. The benefit of continuing of service for all other purposes shall be granted to the appellant, including pension. The monetary benefit payable to the appellant shall be released within a period of 4 months from the date of this order. This is in regarding Bijoy Shankar Mishra and Virendra Dubey. Then para 25, my lord, in both the aforesaid decision, the court took into consideration of the fact that there was no application of mind by the authority to the relevant aspects which were taken into consideration while exercising the power under Rule 13 of the rule. In both the aforesaid cases, court took the view that mere fact that personnel has crossed the threshold of few rating countries could not have been made to a ground to discharge them without considering other relevant circumstances, more particularly the nature of violation which led to award of rating country. The crux of the ratio of the decision of this court in case of Virendra Kumar Dubey is that the only safeguard against arbitrary exercise of power the authority would be to ensure that there is an inquiry. However, summary and a finding about the defense set up by the individual besides consideration of the factors made relevant under the procedure. The reliance placed by learned counsel appearing for the respondent on decision of this court in case of Sattur Singh is of no avail. They have relied, my lord. It was a case in which appellant failed to furnish any explanation of his absence from the duty on 7 occasions. On fact, this court took the view that as the absence from duty was on several different occasions for which he was imposed punishment of imprisonment, the order of discharge could not be said to be unjustified. We may elaborate the aforesaid a little further. Where an act or statutory rules framed thereunder left an action dependent upon the opinion of the authority concerned by some expression as is satisfied or is of opinion, or if it has reason to believe, or if they are considered necessary, the opinion of the authority is conclusive. If the procedure prescribed by act or rules for formation of the opinion was duly followed, if the authority acted bona fide, if the authority itself framed the opinion and did not borrow the opinion of somebody else, if the authority did not proceed on a fundamental misconception of law and the matter in regard to which opinion had to be formed, the action based on the subjective opinion or satisfaction, in our opinion, can judicially be reviewed first to find out the exercise of the facts or circumstances on the basis of which the authority is alleged to have formed the opinion. It is true that ordinarily the court should not inquire into the correctness or otherwise of the facts found except in a case where it is alleged that facts which have been found existing were not supported by any evidence at all, or finding in regard to circumstances or material so perverse that no reasonable man would say that the facts and circumstances exist, the court will not readily defer the conclusiveness of authority's opinion so as to exercise a matter of law or fact upon which the validity of the exercise of power is prescribed. The doctrine of reasonableness thus may be invoked where there is no reasonable ground for formation of any authority's opinion. Judicial review in such a case is permissible. when we say where the circumstances or material or state of affairs does not at all exist to form an opinion, and the action based on such opinion can be quashed by the court, we mean that in fact there is no evidence whatsoever to form or support the opinion. The distinction between insufficiency or inadequacy of evidence, no evidence must be, of course, be borne in mind. A finding based on no evidence as opposed to a finding which is merely against the weight of the evidence is an abuse of power which courts necessarily are loath to interfere. Whether or not there is evidence to support a particular decision has always been considered as a question of law. It is in such a case, it is said that authority would be deemed to have not applied in mind or did not honestly form its opinion. The same conclusion is drawn when opinion is based on irrelevant matter. In case of so it was held that existence of circumstances is a condition precedent to form an opinion by the government. The same view was earlier expressed in case of so. Secondly, court can inquire whether the facts and circumstances so found to exist have a reasonable nexus with the purpose for which power is to be exercised. In other words, if an interference from facts does not logically accord with or flow from them, the court can interpret them as an error of law. Thus, the court can see whether on the basis of facts and circumstances found, any reasonable man can say that opinion as this form can be formed by a reasonable man. This would be a question of law to be determined by the court. Thirdly, court can interfere if the constitutional or statutory term essential for exercise of power has either been misapplied or misinterpreted. The courts have always equated the judicial review with review for error of law and have shown their readiness to quash an order if the meaning of the constitutional or statutory term has been misconstrued or misapplied. Fourthly, it is permissible to interfere in a case where the power is exercised for improper purpose. If a power granted for one purpose is exercised for a different purpose, then it will be deemed that the power has been validly exercised. If the power in this case is found to have been exercised genuinely for the purpose of taking immediate action but has been used only to avoid embarrassment or wreak personal gain, then the power will be deemed to have been exercised improperly. Fifthly, the grounds which are relevant for purpose for which the power can be exercised have not been considered, or grounds which are not relevant and yet are considered, and order is based on such ground, then the order can be attacked as invalid and illegal. In this connection, reference may be made so. On the same principle, administrative action will be invalidated if it can be established that authority was satisfied on the wrong question. At this stage, it may be foresight to refer the Assam Rifle Regulation 2016. We are conscious of the fact that this regulation do not apply to the case in hand as the order of discharge is of 2004. However, we deem fit to reproduce the relevant regulation, more particularly 107C and 108 respectively, as these regulations seem to have been enacted and brought into force having regard to the ratio of decision of this court in case of Virendra Kumar Dubey. So this regulation already I have explained, my love. Then discharge on the ground of rating entry 108. May I read?
What to say about the judgment? One thing.
My lord, lastly, my lord, there are 39 last para. Having regard to nature of misconduct alleged against the appellant, we are of the view that ends of justice will be met if we set aside the order of discharge and treat the appellant herein to have been in service till the time he could be said to have completed the qualifying service for grant of pension. We are inclined to pass an order with a view to substantial justice, as there is nothing on record to indicate that the nature of misconduct leading to award of rating was so unexpectable that the competent authority has no option but to direct his discharge to prevent indiscipline in this force. The order of discharge passed against the appellant is hereby set aside. The appellant shall be treated to have it in service till the time he would completed the qualifying service for pension. My lord, this I want this much only because, my lord, I have rendered a reasonable time, my lord. I have represented the department in many times as I am a good boxer, my lord. And after 10 years serving continuously 10 years in 2000, last part 17, I, my lord,
Narendra Yadav does not overrule Balwant Singh. Does not overrule.
Balwant Singh, my lord, it is in Virendra Kumar Dubey, my lord. Balwant Singh is, my lord, stated.
What?
No, it is of, my lord, Dubey is of 2022.
No, but
2022.
the earlier judgment is not been set aside or overruled. If Narendra Dubey is on the back of that,
Yes, my lord. My case is also, my lord.
but Balwant Singh has perhaps more equity.
My lord, Virendra Kumar Dubey also, in Virendra Kumar Dubey also, Balwant Singh was, my lord. It was discussed, my lord.
Was discussed, but
No, well, it was said,
where
my
is
lord.
the discussion?
My lord, page 163. My lord, my second judgment, Virendra Dubey. See, my lord, 24. Reliance upon the recent judgment of this court, Union of India versus Balwant Singh, is also misplaced, my lord. The grievance of the respondent in that case,
Which paragraph?
20.4, page 163, annexure 2 of my affidavit.
Yes.
20.4, reliance upon the recent judgment of this court in the Union of India versus Balwant Singh is also misplaced. The grievance of the
You're reading from Amarendra Pandey.
no, it is second, my lord, second annexure 2 of my affidavit in reply. First, Amarendra Pandey, my lord.
Yes. Page number.
Page, my lord, 163. 163. Para 20.
You're referring to Virendra Pandey.
Yes. Amarendra Kumar Pandey is of 2022. Then, my lord, Virendra Dubey is of 2015. Virendra Kumar Dubey is after Balwant Singh. Reliance upon the recent judgment of his court in the Union of India versus Balwant Singh is also misplaced. The grievance of the respondent in that case primarily rested upon the alleged excessive punishment meted out for the rating entries suffered by him. The respondent also claimed to have been discriminated due to discharge from armed force. This was also not the case where discharge order was challenged as bad in law on the basis of irregularities, not was in a case where authority was said to have failed to follow the safety. In the result, the appeal succeeds and allowed. The order of discharge passed against the appellant is set aside. Since the appellant has already crossed the age of superannuation, interest of justice will be sufficiently vested if we direct the appellant shall be detailed to have been in service till the time he would have completed the qualifying service for grant of pension. Then, my lord, next annexure, kindly see annexure 3. Here, my lord, I am reading only relevant, my lord. Para 9, page
Oh,
173.
hold on. We are with you. Just wait for a while. Virendra Dubey is uh, uh, under the army.
Indian Army, Lord.
Army, my lord. However, it is discussed in all cases, even on the basis of Virendra Dubey, my lord. Central government employee, they have passed their advisory. My lord, I have already, my lord, stated. And in Ambarendra Pandey, that is from Assam Rifle. Here also, Virendra Kumar Dubey is, my lord, broadly discussed, my lord. So that will not come that central government, my lord. Same footing.
You are referring to the third.
Annexure
Which one?
3, Annexure 3, page 165. My lord, I am reading only relevant last two page, para 8. In the present case, it is evident that there is
You
no
have to tell us what are the facts involved here.
same, my lord. Discharge was given, my lord, after rendering here, my lord, 13 years of service, 4 rating entry. Court has allowed up to the age of pension.
Yeah. Yes. Paragraph.
Paragraph 8, my lord, page 169. In the present case, it is evident that there is no application of mine by the authorities to the circumstances which have been taken into consideration while exercising the power under Rule 13. The mere fact that the appellant has crossed the threshold of 4 rating countries could not be a ground to discharge him without considering other relevant circumstances, including the nature of violation which led to award of the rating countries, whether the appellant has been exposed to duty in harsh session and to difficult living conditions, long years of service, just short of completing the qualifying period of pension, even after the Madhya Pradesh High Court specifically directed consideration of his bearing in mind the provision of the circular, the relevant factors were not borne in mind. The order was passed on 26 February 2007, failed to consider the relevant and germane circumstances, and does not indicate a due application of mine to the requirement of the letter of Army Headquarters dated so and so, and the circular dated so and so, For this reason, we are of the view that Armed Force Tribunal was error in rejecting the application. The orders of tribunal were set aside since the appellant would have attained the age of superannuation. The end of justice would be met if he is treated to have been in service. Till that time, he would have completed the qualifying service for grant of pension. No backwages.
Yeah.
This is then my lord last annexure. Annexure 4, my lord, of this honorable court, my lord, page 172.
17.
Annexure 4, 172, it starts from relevant page 173, para 3, my lord, I am reading. Para 2, he was enrolled on. May I read?
Yeah.
While the petitioner was serving under 7 Assam Rifle, he was awarded 4 rating entry in his service record. A so-called notice was issued to petitioner on Iman, to which petitioner replied to that. The authority by letter dated so after consideration of the reply given by him found his reply to be unsatisfactory, and a decision was taken to discharge the petitioner from service. Accordingly, by order dated 23rd of May 20, petitioner was discharged from 7 Assam Rifle, being an incorrigible offender with effect from 1st June 2020. Being aggrieved with the discharge order dated 23rd of May 20, the petitioner has approached this honorable court by way of this present petition. The respondents have filed counter affidavit in paragraph 2. It is stated that brief of the case, my lord. Rifleman so and so was enrolled in Assam Rifle on 19/10/2009, was posted to so and so, and after completion of petitioner was tried summarily on 4 occasions between 2017 and 19 for the act or omission on his part, and he was awarded 4 rating entry in his service dossier. Details are given, my lord, here. 3 days rigorous imprisonment under section 35 of Assam Rifle Act for an offense of intoxication. Then 7 days rigorous imprisonment under section 26B, an offense without sufficient cause overstaying the leave granted to him. Then 7 days rigorous imprisonment under section 26B without sufficient cause overstaying leave granted to him. Then 28 days rigorous imprisonment on even under section 41B for losing by the neglecting identity card the property of the government issued to him for his use. Here also, on 4 occasions, he was given 4 rating entry. Learned counsel for the petitioner submits the discharge of the petitioner due to 4 rating entry in his service dossier was done in a mechanical manner, and gravity of 4 rating entry was not considered by the competent authority while discharge order dated 23/5/20 was passed. He also submitted Honorable Supreme Court in case of Virendra Kumar Dubey versus Chief of Army Staff report and so held. Therefore, rating amply simply pushes the individual concerned into a gray area where he can be considered for discharge. However, just because he qualifies for such discharge does not mean that he must necessarily suffer the fate. In the present case, it is submitted the 4 rating entry in his service dossier are not serious, and therefore the impugn order deserves to be interfered with. Mr. G. Pegulanet, appearing on behalf of the respondent, on the other hand, submitted petitioner is serving under 7 Assam Rifle, which is a disciplined force. Therefore, 4 rating entry would automatically mean the service of the petitioner is no more required, as he is an incorrigible offender. Accordingly, impugn order was issued. He also submitted petitioner was so caused before issuance of impugn order, and after consideration of reply, discharge order was issued. I have heard the learned counsel. The 4 rating entries entered into service dossier has already been extracted herein above. This court has also considered the advisory. I have annexed, my lord, advisory
Where is that advisor?
Advisory, my lord, I have read in my writ petition. Annexure 6,
Petition.
my writ petition, my lord. Annexure 6 is 38.
Yes, carry on.
The relevant portion of the advisory is quoted below. Keeping in view of the judgment and order dated 16 October 2015, the competent authorities at all level make the cognizance of the following during application of mine while exercising the disciplinary power for discharging an individual from the service on incurring 4 rating. The case of each individual on incurring 4 rating entries to be examined for its own merit, depending upon the nature and gravity of offense and the aggravating circumstances under which this offense were committed by the individual. Discharge from service on incurring 4 rating is not a mechanical process. The termination of service is warranted on the merits of a particular case, and each case has to be examined in detail based on facts and circumstances. The total service rendered by an individual should be considered. Whenever possible, individuals should be given an opportunity to complete a qualifying service for grant of pension. Before discharging an individual from service for incurring 4 rating, adequate opportunity should be provided to the individual for his defense by way of convening an appropriate inquiry. A perusal of the advisory issued by the Minister of Home Affairs, Director General would clearly indicate that incurring 4 rate entries should be examined on its own merit depending on the nature and gravity of offense and the aggravated circumstances under which this offense were committed by the individual. And the discharge from service on incurring 4 rating entry is not a mechanical process. This is held by court, my lord. On consideration of 4 rating entry awarded to the petitioner, it is seen that he underwent 3 days rigorous imprisonment for offense intoxication, 7 days rigorous imprisonment for an offense of overstaying leave, 7 days rigorous imprisonment for the offense of overstaying leave. Then for losing of identity card 28 days, assuming that the first 3 rating entry are serious. The court is of the considered opinion that the 4th rating is a matter which needs to be consideration by the respondent in as much as losing identity card may be beyond the control of the petitioner. In case of Virendra Kumar Dubey, Supreme Court held that the government has a rigidly mentioned by the learned counsel for the appellant stipulated not only a show cause notice, which is an indispensable part of the requirement of the rule, but also an impartial inquiry into the allegation against him in which he is entitled to an adequate opportunity of putting up his defense and adducing evidence in support thereof. More importantly, certain inbuilt safeguards against discharge from service based on 4 rating entries have also been prescribed. The first and foremost is an unequivocal declaration that mere award of rating entries to an individual does not make it discharge mandatory. This implies that 4 rating entry is not some kind of Lakshman Rekha, which if crossed would by itself render the individual concerned undesirable or unworthy of retention in the force. Award of 4 rating entry simply pushes the individual concerned into a gray area where he can be considered for discharge. But just because he qualifies for such discharge does not mean that he must necessarily suffer defeat. It is one thing to qualify for consideration and entirely different thing to be found fit for discharge. 4 rating entries in that sense take the individual closer to discharge but does not push him over. It is axiomatic that commanding officer, even after the award of such entries, required to consider nature of offense for which such entries have been awarded, and other aspect made relevant by the government in the procedure it has prescribed. This court has also considered the communication dated so-and-so by which the reply given by the petitioner was held to be found unsatisfactory. On consideration of same, it appears that communication dated was issued in a mechanical manner without giving any due consideration to the gravity of 4 rating entry enter into service dossier of the petitioner. No reason have been assigned in the communication dated so-and-so indicates so as to why the reply given by the petitioner found to be unsatisfactory. In my case also, my lord. On consideration of the same, this court is of the considered opinion that discharge order is hard without considering the gravity of offense involved in the matter. In view of the above, impugn order is set aside and quashed. Respondents are directed forthwith to reinstate the petitioner back into service. Title that case. Well, so my humble prayer, as I have given a long period of my life, I may be allowed only up to the age of my pension.
Is that it?
My age,
Years?
60 years superannuation, my lord. I am only 41 years.
You got 20 years, 19 years.
Is my age.
Oh.
41, 40.
You're 41 years. You
40.
want to continue 60 years.
Yes, my lord. No, my lord, for pension, I should complete 20 years. I have 2008, my lord, I was enrolled. In 2028, I will complete 20 years.
Yes, all right. What is the value of this advisory?
Lordship, if we have not followed rule regulation 108, if some provisions are there, you just cannot throw someone. So in this case, Lordship, all the procedure has been followed. We have given all opportunity to the petitioner. Birendra Kumar Dubey case, Lordship, there was no so cause notice was issued. Here, Lordship, we have given him warning that after this, you.
Therefore, I am asking for value of this advisory.
The advice.
Follow this advisory
Yes.
or
Lordship, the advisory has been followed in this case also, Lordship. All so cause notice. First, we have given him a warning letter after 3 rating entries that this will be the outcome if we will have incur any other rating entries, Lordship. There is no improvement. In fact, Lordship, after the stay order, also the petitioner is not cooperating with the authorities, and he is not even working in the name he is there, but he is not actually working in the under the department also, Lordship. He is still in intoxication. Here, Lordship, so cause notice, etc. And the
still in the intoxication?
yes, Lordship. That
Let's
is
give us the record.
records. How could Lordship, because he is not working and he is just.
Right. How to say
No, that is the verbal instruction given to me that he is still not.
Are irrelevant. Do you have any medical report for it?
After this stay order also, Lordship, there is. I want to say that there is no improvement in his
Been
conduct.
subjected to any medical tests to show that still he remains under intoxication or anything.
Lordship, as after stay order, he is.
Stay order does not prevent you from undertaking
Lordship,
medical tests.
basically that was not done, but that is that he is to show that he is still not improve his conduct, Lordship. He is.
Where are the materials to say that? Where
that-
are the
that
materials
is-
to say
that is-
that notwithstanding the interim order, notwithstanding that he is discharged in state, he is getting his salary, this is his conduct? Where have you brought?
But that is a different aspect, Lordship. But so far this case is concerned, Lordship, I am relying on 3 judgment, Lordship. The recent and final judgment, that is Satish Kumar Jadhav, that I have already submitted, Lordship. In that case, all the judgments that were submitted by my learned colleague has been discussed, and she is the petitioner in that case. Only difference is that in that case the person has already gone for pension, and here a stay order is operating. Otherwise, the fact of the case is also same, Lordship.
Can you give us the citation here
Satish Kumar Jadhav is the recent judgment, Lordship,
of this court?
of this court. Another coordinate bench, Lordship.
Not here.
Lordship, I will submit another one. WBC number 5548 of 2021. It was decided on 27/5/2025. Yes, Lordship, I will submit. There is another one is Binu D, Lordship, and the one is that what type of inquiry has to be done. That is also discussed in the case of Sipai Sadhguru Singh, although it is an armed forces, but the here the inquiry, it is not a regular inquiry, it is almost a preliminary inquiry. And in my affidavit, I have annexed all the proceedings, 5 charges against him. All the proceedings I have annexed that where he had entered, how to do that, those are there, Lordship. How to conduct the inquiry, those things are also there.
Where is
And
your affidavit?
yes, Lordship. My affidavit starts from page, this proceedings I have annexed starts from page 93. 93 up to 103. Page 80 is also there. Page 80.
Which is the relevant? 93.
93. 93 is regarding that first offense.
No, these are not required. After you give him the warning letter,
Yes, Lordship.
you are required to
Page
examine
99 and 101. That is the 4th and 5th offense.
99.
And 101. So instruction is also there how to do it. We have these proceedings were never challenged, Lordship. Neither even the warning letter was also not challenged. Only the discharge order was challenged, and this discharge order is the.
What is 99?
This is record of proceeding before commandant for
Which proceeding?
this
Relating to which offense?
offense. This is for 4th offense.
4th offense.
Yes.
Then
101.
for
This is for the 5th offense.
no, what we want to know is this advisory which you have there.
Lordship.
You come clause 3 of the advisory. Page 39.
Yes, Lordship.
See, the procedure is written there. What is
This
to be
is,
done?
Lordship, in accordance with this Birendra Kumar Dubey. The main distinction between this present case is Birendra Kumar Dubey is that in that case, Birendra Kumar Dubey, no so-called notice was. But
That-
here,
That is all right, but here you read 3 onward.
in the result, this appeal succeeds and is hereby allowed.
No,
The-
no, it is advisory.
Yes,
Page
Lordship.
39.
Yes, Lordship. Page 39. 3. Keeping in view the judgment and order dated so and so, the competent authority at all level must take cognizance of the following during application of mind while exercising the disciplinary power for discharging an individual from service on incurring 4 rating entries. The case of each individual on incurring 4 rating entries should be examined for its own merit depending upon the nature and gravity of the offense and the aggravating circumstances under which those offenses were committed by the individual. Discharge from the service on incurring 4 rating entries is not a mechanical process. The termination of service is warranted on the merit of a particular case, and each case has to be examined in detail based on facts and circumstances. The total service rendered by an individual should be considered, and wherever possible, individuals should be given an opportunity to complete the qualifying service for the grant of pension. Before discharging an individual from service incurring 4 rating entries, adequate opportunity should be provided to the individual for his defense by way of convening an appropriate inquiry. So inquiry we have conducted. that is at the time of this issuance of this discharge order, he that is of 11/8/20. He had completed 11/8/24. He had completed 15 years, 7 months, 21 days.
Yeah.
So now less than 16 years, Lordship. And 108 clause C said that if he had completed more than 18 years, then you should consider that up to 20 years if he could be he could be allowed to continue, Lordship. But here he had not even, he will be completed 20 years in December 28. So this is not applicable in case of the petitioner, Lordship. Under 108C also, Lordship. He had not completed even 16 years at the time of issuance of this discharge order, Lordship. Then, and all the
What is the implication of 3A?
103A, Lordship. The case of his individual on incurring for, yes, Lordship, in our show cause notice and warning letter, we have given the reason that why it, Lordship may kindly come to my show cause notice, and that is there, Lordship. Warning letter also, Lordship, will find at page 71, and show cause notice also at page 73. A. Appeal on 4th May 2017 at so and so hours, individual absented himself without leave from COB Jupta, and individual voluntarily rejoined at so and so
Wait.
on.
We are not asking you that you are not questioning that you did not issue. I am trying to understand what is the implication of 3A. See, there are 4 different rating entries. These rating entries were on the basis of misconduct he had committed. You proceeded with an inquiry, punishment imposed. Those chapter is closed. No appeal has been filed. But it entails in a rating entry. Likewise, 1, 2, 3, 4 different rating entries. Now, if you read 3A, it says it has to be examined on its own merit. What is the meaning of that?
That is why, Lordship, this summary proceedings.
What is the meaning of that?
Yes, Lordship, under what circumstances he had done, etc.
That is already the result of the proceeding. What more is to be examined?
That is, Lordship, that is
You have arrived at a finding. Does it mean that you will reopen those proceedings? Perhaps not.
These types of this amounts to raiding entries, Lordship, and raiding entries he had.
You read 3A. Read 3A.
Lordship.
This is on incurring 4 rating entries.
So there, we have the recommendations are there, but Lordship, that those are part of the confidential document, but I can give it to Lordship. Decision of competent authority, etc. are there, Lordship. So one is that recommendation of the commandant is that.
This is just a warning. 71 is a warning.
Yes, Lord.
The warning letter. That 73 is a show cause letter.
Notice.
Show cause.
Yes. And in his show cause notice, and also at page 88 and 91, he had admitted 2 of the offenses. So it cannot be said that.
So therefore, we are asking you what is the implication of clause 3A of the advisory. This is the advisory is issued by your Assam Rifles.
Assam Rifles advisory is it 2021 subsequent this judgments were Lordship this.
You have to give some meaning to it. What is the meaning of that? What is the meaning of that? What does it imply? It obviously does not imply that you reopen the proceeding on the basis of the ticket.
Lordship. So these types of my learned friend had already stated that we have stated that he is an incorrigible offender, Lordship. At page 47, we have stated that after a person who commits mistakes again and again, Lordship, he can be treated as an incorrigible offender, and as he is an incorrigible
Person, the reply submitted. What happened? To pass the order.
Lordship, he has admitted two of the offences.
After you have given it the propose,
Lordship.
he has submitted a reply.
That is only an advisory, Lordship, and Rule 108 of the regulation is very much clear, Lordship. What is the procedure to be adopted?
No, this is an advisory, but what is the context of an advisory if you don't intend to follow it? By Assam Rifle.
That's true, Lordship, but that at that time maybe for some cases, but 108 is very clear, and all the cases 108 has been discussed, Lordship.
After you issue the warning, you issue him a show cause. After the show cause, he gives a reply. Then what happens?
Lordship, 108 we have stated, Lordship. Here it is also there, Lordship, page 50. Each case of individual having earned 4 or more rating entries shall be examined on its own merit, depending upon the nature and gravity of the offences and the aggravating circumstances under which these were committed. The authority competent to sanction discharge order under this para shall record reason for ordering the discharge or otherwise.
But we want to know that after the reply, you issued the discharge order. After the show cause
Yes,
notice,
show cause we have given to give him a
the
satisfactory
final reply. Then what happened? You passed the discharge order.
We are not satisfied with his.
Prior to passing the discharge order, was there any attempt to evaluate whether this discharge is all called for?
Yes. Yes, Lordship. Decision of the competent authority, we have also submitted this to the petitioner. Before passing the discharge order, after the so-called reply.
So that's what I'm saying, that you are there is simplicity, the judgment both before and after, as well as that you have decide each case of person earning credit, whether he is required, whether it is retained or discharged. It brings up to the decision. It's not an automatic discharge. Or an entry is out.
No,
That's
not
not
that.
the way it
That is why procedure as per 108 and how to deal this paragraph 5A, 5 of 5, 7 and 8 of this judgment that I have also annexed in my affidavit, Lordship, Sipai Sadhguru Singh versus Union of India and others. That is a part of my affidavit also. So
it will continue tomorrow.
para 5, 7 and 8, Lordship. How to
Tomorrow.
learn.
You have already completed. You're hearing that.
Lordship, may just take up paragraph 7 and 8 of this paragraph. Lordship, may I?
Which paragraph?
That is also I have annexed with my affidavit, Lordship.
You are referring to the judgment.
Yes, Lord.
Quite right. That is what we want to find out. What decision have you taken? You have communicated. You have. This is the decision.
Lordship.
You have communicated. We want to see what is the decision-making process. What have you done? We'll continue tomorrow.
Lord.
Please. Yes.
Lordship already heard the matter length, and only that day also my friend produced the record, but because of the paucity of time, it won't be done, my lord. Any day, any after vacation, my lord, it may be treated as part of, because already Lordship heard the matter. Other,
Let it come up.
my lord,
What is the issue?
Lordship, this is regarding disciplinary proceeding, my lord, expert in disciplinary proceeding. He was removed, and now, meanwhile, when the writ petition was pending, he was expert due to motor accident, my lord. Now only the wife and 2 kids are there, my lord. They are entitled for the pension benefit. For that only, my lord. Now, of course, they are also otherwise they are showing they are wiser to give the pension, but because of this removal order, my lord, they are getting some.
Item 25, 26. First week of August.
Can it be, my lord, my prayer, humble prayer, my lord, since Lordship heard the matter, can it be a part of, my lord, since it has been said further hearing? Lord.
Item 23.
Obliged, Lord.
Yes, can it be in the next week, Mala?
Next week, yes, that no inquiry report.
Yes, the inquiry report.
No.
Never.
Not only the inquiry report, Mala. No procedural procedures has been followed.
The hearing day, you
On Tuesday.
No, Tuesday, except Tuesday or any other day, Mala. Can it be on Thursday, Mala?